This meeting will come to order. This is a meeting of the Joint Agriculture and State Public Lands and Water Resources. Welcome everyone. Roll call, please.
Good morning, Mr. Chairman. This is roll call for Monday, June 6th for the Joint Ag Committee. Senator French. Here. Senator Kolb.
Present.
Senator Cost.
Here.
Senator Wasserberger.
Here.
Representative Blackburn.
Here.
Representative Clausen.
Here.
Representative Fortner.
Here.
Representative Heiner.
Here.
Representative Larson.
Here.
Representative Western. Here. Representative Worf.
Excuse.
Representative Winter. Co-Chairman Boner.
Here.
Chairman Eklund.
Here.
Mr. Chairman, we have a quorum.
Okay, thank you. We're going to hear a word from a guy who doesn't usually show up in agriculture, but our education guy, Matt Wilmarth, is here. Go ahead, Matt.
Good morning, Mr. Chairman, members of the committee. You are correct. This is not my normal committee. For those who don't know, my name is Matt Wilmarth. I am a senior school finance analyst in the LSO's Budget Fiscal Division. Thank you for the opportunity to present this morning. This is in relation to your number one priority on state leasing of state lands. And the reason I'm here is to give a little bit of a background on the income that is used to support schools off of the state school trust lands. A majority of the state trust lands in Wyoming are for the public benefit of Wyoming's K-12 education system. Feel free to ask questions throughout the presentation. Pause me if you have any questions. With that, Mr. Chairman, today's presentation will touch on two areas. The first is the federal land grant program and the trust lands that are associated with that and how that program was established in Wyoming. And then I'll talk about the revenues that are derived off the state trust lands for purposes of schools. And then I'll talk about the two accounts that the two operational accounts, the school foundation program account and the school capital construction account, on where those revenues are received and appropriated for purposes of K-12 education. So a little background in the federal support of public schools goes back more than 2 centuries to the Land Ordinance Act of 1785 and the Northwest Ordinance Act of 1787, which granted federal lands to new states and set aside a portion of those lands to fund public schools. The nation's founders saw these lands as a way to encourage public education throughout the West and incorporate the principles of democracy throughout the Western Territory. Initially, the first state, Ohio, was granted lands, and each section 16 of each township was set aside and reserved for public schools. As additional states came on, admitted to the union, additional sections were set aside for public education. For Wyoming, sections 16 and 36 were set aside, and Arizona, New Mexico, and Utah were a little bit unique. They have 4 sections that are set aside for public schools. So as Wyoming's active admission, as I mentioned, section 16 and 36 were set aside for purposes of K-12 education, and or any equivalent lands that had been previously sold or granted. Also, an important point is the source of revenues. So under Wyoming Constitution, Article 7, Section 2, that really specifies how the school lands revenues are used for the support of public schools. So any sale of the lands will be deposited within the corpus of the common school account, permanent land fund. And then any leases or bonus payments will be utilized for the operation of K-12 public schools. And then 2/3 of any mineral royalties are then deposited up to 2/3 or 2/3 of mineral royalties are deposited in the corpus of the common school land income or common school permanent land fund. Up to 1/3 can be used for purposes of operations of schools. And that has changed in the past couple of years, and I'll get into that shortly. So initially, if you see on the screen here, Ohio was the first state that received initial common school acres. Wyoming was initially awarded 3.47 acres. And you can see, as I mentioned earlier, New Mexico, Arizona, and Utah have a little bit more than Wyoming. Again, this is primarily because they set aside 4 sections rather than the 2 sections than the majority of the other states. One state that you'll notice that isn't highlighted is Texas. Texas actually did reserve Section 16 lands for its public schools, but it was a republic, and it was actually not granted federal lands. They had actually taken the initiative before then, so that's just a little bit nuance. Of the total state lands, about 86% are public schools, and that equates to about 3 million surface acres and 3.4 million mineral acres. Those all benefit the public schools. As I mentioned earlier, the sale of lands are deposited into the common school account within the permanent land fund. 2/3 of mineral royalties, any easements or damage payments. This is a new one. The additional 1/2 of the additional 1% of severance taxes that began in fiscal year 21, and then any other transfers or appropriations to the common school account. An example of that is when we get into discussing the investment earnings on the permanent land fund. We tip from the reserve account, the common school permanent land fund reserve account, any excess revenues in excess of 150% of the 5-year average of the corpus. So really what makes up the revenues related to the common school land fund? I broke these into land activities and then the distributions to the school foundation program account and the school capital construction account. So on the land activities, over the past 15 years, approximately $2.9 billion has been generated from the land activities. And this consists of approximately $466 million from renewable activities. And these would be leases that you're discussing this morning and any bonus payments that are also received. 2.3 billion has been generated from non-renewable activities. These are the state mineral royalties on school lands for oil, gas, and coal minerals. The remaining 164 million that has been generated over the past 15 years are from other activities and primarily from land sales and right-of-way easements and surface damage payments. That's approximately 6% of the total. So shifting to the right side, the bar graph, how much has been distributed to the school foundation program account and the school capital construction account? Approximately $2.7 billion over the past 15 years, and primarily the 76% of that revenue comes from investment earnings off of the corpus of the common school account within the permanent land fund. Approximately $670 million has been generated through the land activities. So historically, only about $8 million of the state royalties were distributed each year to the school capital construction account. The past, beginning in fiscal year 2019, the full 1/3 allowed by the state's constitution, Article 7, Section 2, has been distributed to the capital construction account, and now more recently the school lands mineral royalties account.
Mr. Wilmarth, could you hang on a bit? We've got a question here.
You bet.
Yeah, Vice Chair Clausen, go ahead.
Thank you, Mr. Chairman. Mr. Milmarth, It looks to me like in these graphs, the last 4 years, we've had diminishing returns on our land activities. Would that be kind of consistent with your analysis of what's been going on? Is there an explanation, an oddity, or some sort of a reason for this?
Mr. Chairman and Representative Clausen, good question. So this gets into the state royalties change in law. Prior to 2019, the legislature capped the amount of state royalties distributed for purposes of supporting K-12 education or school capital construction at $8 million per year. Beginning in fiscal year 19, the full 1/3 of the state royalties was distributed to the school capital construction account. So that's why you see an increase in that blue graph, or the blue bar on fiscal year 19, is that increased distribution of state minimum royalties. And to kind of give you an idea, in fiscal year 19, a total of $139 million of state royalties was received. Previously, only $8 million of that would have been distributed. But in fiscal year 19, 1/3 of that $140 million was distributed to the school capital construction account.
Follow up, Representative.
Thank you, Mr. Chairman. Mr. Wilmarth, my question was more pointed towards the income side. It looks like diminishing returns from 2017, 2018, 2019, 2020, 2021. And is there an explanation for those diminishing returns on land activities? The distribution side, I have a pretty good handle on. The income side.
Yeah. So, Mr. Chairman, you're looking on the right side, and you're looking at investment earnings. The left side, are you looking at the other category?
No.
Or this, you're looking at leases and bonuses? My apologies.
Go ahead, Representative.
The dark blue on your graph, leases and bonuses.
Thank you, Mr. Chairman. Sorry about that, Representative Clausen. Yeah, so in fiscal year 2017, 18, and 19, there were significant bonus payments. So in 2017, $31 million in bonus payments was received. In 2018, $29.5 million in bonus payments were received. And $22.2 million was received in fiscal year 19. In fiscal year 20, only $4.8 million was received. And in fiscal year 21, $2.7 million. So the decrease in the leases and bonuses is more attributable to the bonus decrease than the prior 3 years. The leases have remained fairly constant in that time period between $13.5 million in 2017 to $12.6 million in 2021.
Okay, follow up, Representative Clausen.
Mr. Chairman, Mr. Wilmarth, in your analysis, is there some sort of appointed reason for these bonuses not being there? Is it a policy shift? Is it market trends? Why are we seeing diminishing returns in this area?
Mr. Chairman, and the agency can correct me if I'm wrong, I think it relates more to the market conditions of the commodities for the oil, gas, and coal market. Those bonuses are generally paid on those mineral-related sections of land.
I would have a question kind of down these lines. How long has it been since we got a coal lease bonus payment?
Mr. Chairman, so I want to be careful. The bonus payments we're talking about are on state lands. These are not the federal coal lease bonus payments.
Oh, okay.
And so I'll get into that later on, but you can see the federal coal lease bonus payments have not been received in for some time.
Okay. Yeah, Chairman Boner.
Maybe it'd be beneficial to explain what exactly a bonus payment is, as opposed to, say, lease and so on.
Mr. Chairman and Chairman Boner, my understanding, the bonus payments on state lands are just the opportunity to lease that for the period of the term of the lease. It's an additional payment on top of the lease that a company or a person will go at auction through the Office of State Lands and Investments to apply on that section of land.
Chairman.
Yeah, and Mr. Chairman, sometimes we also call that, in the private sector, we call it rental. And I think that's a pretty easy way of thinking about you're exchanging, you're giving that company exclusive opportunity to develop that property in exchange for a financial consideration. So it's like they're paying rent to be there, have that, that opportunity to develop that property has value, the exclusive opportunity, and nobody else can do it. So bonus or rental, that's the way I think of it.
Yeah, Representative Heiner.
Thank you, Mr. Chairman. We're seeing that these lease bonuses are decreasing, but right now is a perfect time to lease for oil and gas. Do we have any opportunities, and you may touch on this later in your presentation, but do we have some unleased minerals for oil and gas that we could offer for lease at this time on state lands?
Mr. Chairman and Representative Heiner, I'll have to defer to the Office of State Lands and Investments on that. I don't have the knowledge of that specifically. And Mr. Chairman, I would point out in fiscal year 2011, you'll see a significant land activity amount. That is primarily due to $103 million for that 1 year in bonus rental payments that the state received on state school lands. That 1 year is an anomaly in the course of these revenues.
Okay,
Okay.
thank you.
Mr. Chairman, one item I looked at on these common school lands is compared to other states. And so for the purposes of the comparisons, we looked at their common school lands and how much they generate to support public schools. We selected Colorado, Idaho, New Mexico, North Dakota, and compared those to Wyoming's revenue on school lands. For purposes of the comparisons, Colorado common school lands, 98% are for public trust, 98% are for schools. Idaho common school lands, approximately 60% of their total public school or public trust lands are for schools. New Mexico, 85% of their total public trust lands are for schools. And North Dakota, 91% of their public trust lands are for common schools. So Wyoming, again, as I indicated in my opening comments, 86% of our state trust lands are for public schools. We looked at this
We've got a question here, Mr. Wilmarth.
Mr. Chairman, Mr. Wilmar, so I guess the per pupil looks really good in this. Is there some sort of a way to adjust this for population? Because the landmass of all these states are relatively similar to Wyoming, but the population of Wyoming is considerably smaller. When we go per pupil, it sort of skews the information. Is there some sort of a formula we can use that puts us apples to apples?
Mr. Chairman and Representative Clausen, I did not look at this on a per capita basis. I looked at this on a per pupil basis of K-12 enrollment. Certainly could look at it on a per capita basis. The data that I was able to secure was on a per pupil basis for purposes of the analysis, but I can certainly look into that for you. So in terms of how does Wyoming compare to these other four states, generally pretty well. Colorado and Idaho generate approximately, and this is just on their land activities as well as their investment earnings, $197 and $164 per pupil. North Dakota is next at $1,287 per pupil. And then there's New Mexico at $3,083 per pupil. So in terms of the percent of the total K-12 revenue for these states, Wyoming and New Mexico stand out at 15.3% and 24.9% respectively. Colorado and Idaho almost 1.5%, and then North Dakota at 8.1%, and they're increasing. The revenue off of these or for these states primarily come from their corpus or their permanent land funds. Colorado's permanent land fund value as of June 30th of last year was $1.3 billion. Idaho's was $1.9 billion. New Mexico's 26.7 billion. And in terms of how big that is the 31 largest sovereign wealth fund in the world. So New Mexico's 28.7 billion or 26.7 billion. The other state that I don't have on here is Texas. Texas has a $55.6 billion permanent land fund. That's the world's 23rd largest sovereign wealth fund. North Dakota has $5.7 billion in their permanent land fund, and then Wyoming has about 4.4 billion. Again, primarily the Wyoming's revenue is made up from the 2/3 of the state mineral royalties that are the non-renewable activities. As I indicated, the leases, the bonus rental payments, and investment income, those are, again, constitutionally required to be used to support K-12 education. The legislature has directed those to the Common School Land Income Account, and then that is in turn deposited into the School Foundation Program account. This slide here just shows all of the revenues that are for the School Foundation Program account. The third one is that Common School Land Income Account revenue, and that is where the leases and the bonus rental payments and investment earnings are deposited. So looking at the School Foundation Program revenues over the past 15 years, the leases and bonuses don't make up nearly a significant portion of the revenue for the School Foundation Program account. What has changed over the course of the years is the actual investment earnings off of the corpus. As that corpus has increased, the investment earnings in turn have also increased. And if we compare 2005-06 biennium to the
Mr. Wilmarth, we've got a question. Work here, there you go. Mr. Chairman, go ahead.
Yeah, just going back to that previous slide, I mean, that's, and just to be clear, I think the relevant part here is I'm trying to get at least is how much does the investment from our state lands actually contribute to the overall picture? And so with this chart, that's just the state side, right? There's also the local revenue that's generated in our school districts, which I would argue isn't actually local, because if you make too much, the state takes away. If you don't make enough, the state gives you money. We have the wisdom to sit down and try and make an equation to fund our schools that's supposed to work for every last school district, right? And so if we're looking at the actual overall annual funding as dictated by the state, which includes the local revenue, what are we looking at in terms of totals? It's much more than, $1.5 billion, right?
correct, Mr. Chairman. This is only the School Foundation Program side, the state side. The other side, which is the local school district side, is primarily made up of property taxes, the 31 local mill levies. It's almost double. So these are on biennial basis. You're correct. The local ad valorem taxes are, they range, they fluctuate based upon commodity prices. But you're right, the 31 mill levies make up a significant portion. In instances where a local school district has excess local revenues, the state recaptures and redistributes that to other school districts. And you can see that recapture amount is the third bar from the right. It's that kind of dark blue. Recapture revenue has been a significant portion of this School Foundation Program's revenue makeup. So in terms of state leases and bonuses and the investment earnings off of the common school account, when you compare it to 2005, 2006, the state leases and bonus for that biennium equated about $31 million, and the investment earnings was approximately $109.4 million. So in total, about 11% from the common school side made up the total $1.3 billion revenue to the School Foundation Program account. Moving to the estimated current biennium, 21-22, the state leases and bonuses proportion is about 2%, about the same amount, $30 million, but the investment earnings has increased to about $439.4 million, and approximately 28%. So the increase in the value of the corpus has generated a significant portion of revenue. And in fact, if you look at FMRs, the FMRs have decreased about the same difference that the investment earnings have increased. And so the decrease in federal mineral royalties has been made up from investment earnings. I threw this in here just to kind of give the committee an idea of how the school foundation program accounts mix in mineral related and non-mineral related revenues has changed over time. In 2005-06 biennium to the 2021 biennium, it shifted to a mineral related revenue mix to a non-mineral revenue mix. I do caveat this analysis in that the investment earnings are considered non-mineral in my analysis. One could argue that the investment income based on legacy mineral royalty revenue, primarily mineral royalty revenue, are legacy mineral revenues. I consider them just the non-minerals, but that's an interesting shift that the state's school foundation program account has now shifted more to a non-mineral reliant environment. For the school capital construction account, as I indicated, state mineral royalties, up to 1/3 of those is
Mr.
distributed.
Wilmarth, hang on just a minute here. Representative Worth, go ahead.
Thank you, Mr. Chairman. I guess one of the questions I have, are we paying attention to where our investments are, what they are in, or do we just turn that all over to the investment people and they kind of put it where they think it's going to have the best return? And then I have a follow-up.
Mr. Chairman and members of the committee, Representative Worf, again, I'll defer to the state land investment folks. Generally, the state treasurer's office, their investment is approved by the state land and investment board, their investment policies. Their fiduciary responsibility is to garner as much revenue as possible for the state. And I don't know exactly how they go about on looking at that investment policy, but their charge is to generate as much revenue as possible for the state.
Thank you. And if a follow-up, I guess the reason I ask is twofold. Obviously, with the way the economy is going right now, I worry about what happens if this hurricane that's supposedly on the horizon, what that could possibly do to us with our investments. I know when the housing bubble burst, I know there were some bad investments that we had that we lost on. And I guess the second question I have is, I'm assuming that we have a policy that we aren't investing in companies that are actually working against this state and our mineral industry. I know there's a big push for all this green energy and stuff, and I just worry, and I guess that's something I'd like to hear from those that can address that, is whether or not we are ensuring that we're not investing in companies that are actually working against the interest of the state, as we invest dollars in companies that are maybe working to destroy our economy. So that's a big question I have. Thank you, Mr. Chair.
Okay, and I'm guessing you probably can't answer that. And
Yeah.
I don't know if state lands would be able to either. We'd need the treasurer, probably.
Yeah, Mr. Chair, I was going to say that's why we vote for a state treasurer, I believe. And it sounds like a bill draft, personal bill draft, not sure if it's within the confines of the Ag Committee, but yeah, certainly something we've been talking about in the Federal Natural Resource Management Committee as well. So.
Well, and I assume there's a policy somewhere. I just have not had a chance to review it, but where would I get that policy from? Would I get that from the treasurer's office then? Thank you, Mr. Chairman.
Yeah. Representative Clausen?
Mr. Chairman, back to the last slide, if you would, once you're Wilmarth. So My question, Mr. Chairman, this set of graphs looks fairly alarming. We're either doing a really great job with our investments or a terrible job at managing our minerals when we go from 71.4% to 42.5%. Is there, I guess, I won't ask that directly, but is there an explanation as to why this shift? Are we doing a great job with investments, or maybe could use a little work on the mineral side?
Mr. Chairman, Representative Clausen, it's a combination of both. One is the federal mineral royalty revenues received in prior years was much greater than it is today. But as I indicated, the investment earnings have offset some of that revenue. Another piece of it is a state 12 mil levy in the statewide assessed valuation. The historical assessed valuation was primarily weighted towards minerals, and now it's about equal, 50-50 between mineral-related assessed valuation and non-mineral-related assessed valuation. So the 12 mil levy and the property taxes are about equal. And so that's where you see the shift. So decrease in FMRs, federal mineral royalties, better performance on investment earnings, and the statewide assessed valuation has moved more towards an equal distribution of non-mineral related assessed valuation and mineral related assessed valuation.
Yeah, follow-up, Representative.
Mr. Chairman, Mr. Wilmarth, so the estimate of 2122, I assume that's an estimate. What is the target value of, I assume that's based on WTI. What estimate was that used on? Because we should see an anomaly that bounces that to an extraordinary level. But what was that number, if you do have it available?
Mr. Chairman and Representative Clausen, so this is based on our January CRAG, but the property taxes are based on calendar year 20. So this is prior to what we've seen or experienced this current calendar year on oil and gas prices.
Good. All right, continue on, Mr. Wilmarth.
Thank you, Mr. Chairman. The last two slides here are more targeted towards the school capital construction account. As I indicated, the revenues to the school capital construction account for the state royalties were traditionally only up to $8 million per year from those. In 2019, the legislature modified or amended the statute to provide for the full 1/3 of mineral royalties on school lands to be deposited in the school capital construction account. This is your question, Mr. Chairman, on federal COLIS bonus revenues. That is that dark blue line from 2005-06 to 2017-18. And there was a slight couple $100,000 in 2019-20 of COLIS bonuses. So as part of the legislature's response to no longer receiving federal COLIS bonuses, the state first provided for the full 1/3 of state royalties on state school lands to be distributed to the school capital construction account. The other change recently, for, beginning this biennium, is to set aside 45% of the SIPA's spending policy amount for major maintenance, and that's that gray bar on the right-hand side for the 21-22 and the 23-24 biennium. So when you combine both the school foundation program account and the school capital construction account revenues, the mineral relation and the non-mineral relation, again, has the same trend. It's just a little bit more profound with the COLIS bonus revenues combined in there. So to conclude this morning, Mr. Chairman, the federal land grant program established revenue for public schools. We've kind of discussed those. Wyoming's revenues, as I think I've illustrated, are quite volatile, primarily for K-12 education. And we've seen that shift from a majority of the revenues that are mineral related to a slight majority that are non-mineral related. And this is primarily, we've seen an increase in investment earnings to the school foundation program account from legacy mineral royalties, and that's offset the lower FMRs. And the co-lease bonuses have not been necessarily replaced, but they've been in part replaced by the state royalties on school lands and SIPA income from their investment earnings.
So committee, so you kind of have a understanding of what this was like 10, 12 years ago. The school buildings, the facilities were generally built by co-lease bonus dollars and overflow from the school foundation account, I believe. Am I correct on that?
Mr. Chairman, that is correct.
Okay. Anyway, now we've offset it with other revenues, because I've been here 12 years and I don't think we've had a co-lease bonus payment. We had bids that would have been $400 million, one of them that I can remember way back. But we've figured out other ways of balancing this budget so that we can continue to keep up the facilities in the school facilities in the state. Correct?
That is correct.
All right. Any questions before we move on? All right. Thank you, sir. Okay, so next, folks, here will be our Office of State Lands, or you, I believe.
Mr. Chairman,
Yes.
we also have Lucas Plum with the specifics on state land leasing.
I'm sorry. Okay. Let me get back to the script here. Okay. So LSO, come on up and.
Good morning, Chairman Eklund, members of the committee. My name is Luke Plum. I'm staff attorney for the Legislative Service Office. And I had prepared the topic summary that just gives the broad overview of state land leasing. And so this morning I was just prepared to just give a general overview of that memo that I prepared and provide some background information. The paper that I put together, it generally covers the statutes for state land leasing, specifically in Title 36, leasing generally. Also, I touched on the mineral leasing statutory provisions. I just briefly addressed some other approaches by the surrounding states, a little bit of case law, and then there's also past, proposed, and enacted legislation that I included in a chart at the end of the paper. And so just jumping in, just to start, I guess, important statutory definitions. The board generally, as I refer to it throughout the paper, as the Board of Land Commissioners, which are the top 5 statewide elected officials. And they're important because they are charged with the direction, control, leasing, specifically care and disposal of all lands to public schools or any purpose that is established in the Constitution or by the legislature. The director, when referring to them, is the director of the Office of State Lands and Investments. They're the secretary of the board. They keep records for the board, and they also accept applications for and manage state land leasing. And so then there's just also statutory definitions of state lands, school lands, and institutional lands. And those are just generally the ones that are under the control of the board, have been acquired by the state of Wyoming from the United States to support public schools, and then just any other lands for the benefit of the state. And also I'll be referring to old lessees, and those are just the person or entity that is listed as the leaseholder for an expiring lease. So specifically getting into Chapter 5, leasing generally, there are qualifications that you have to meet in order to lease state lands. You have to have reached the age of majority. You have to be a citizen of the United States. You have to comply with the laws of the state of Wyoming, and you have to be authorized to transact business in the state. And then once a lease is awarded, there's rentals are based on an economic analysis to reflect fair market value. That's a very specific, important provision throughout the leasing statutes that has to be based on fair market value. And that's on a formula adopted by the board. And they just have specific criteria that they should be using readily available data, averaged over several years to adjust for any fluctuations. They have to consider factors reflecting true fair market value. There has to be parameters for the board to respond to changing conditions in the market demand, industry viability, and then also factors reflecting contributions made by the leasee. And so generally, yeah, there's just a max term for agricultural or grazing leases of 10 years. And when you are when you're an applicant applying for a lease of state lands, you have to pay the regular filing fee with the Office of State Lands Investments. You have to provide the first full year's rental. And if there have been any improvements, you also have to pay for the use of the improvements on the land that you're going to lease. And that's in addition to the filing fee and the first year's offered rent. And if the applicant fails to or refuses to complete the lease, then the application can be denied. There's a 30-day notice process, but if an application is denied, then the applicant's rental payment and 25% of the payments made for any improvements, if that's applicable, are retained by the board as liquidated damages. And they're credited to the appropriate permanent land income account or to the general fund if it's an improvement payment generally. But that's just kind of the first general overview of actually leasing state land. And then if you're going to renew an agricultural or grazing lease, that's an entirely different important process. There is a requirement if you're renewing, you have to have your application within 120 to 30 days before the expiration of the lease. And then there is a process if you want to apply, if there's a previous leaseholder who is seeking renewal and someone else seeks to also lease that land. It's called a conflicting application. It's more so in terms of a competing application. And conflicting is just kind of the term that is used by the Office of State Lands and Investments. And as far as I understand it, and those applications have to be filed 120 to 90 days. So it's a shorter window before the expiration of the current lease if you want to try and do that. And so then getting into the main meat of the renewal process, that's in Wyoming Statute 36.5.105. And I will note, and I tried to make this noted in the paper as well, that there's the current process, but then 2022 House Bill 3 has made some changes. So I'll just try and briefly hit both of those. To lease state lands for an agriculture and grazing process, it requires the board to inure the greatest benefit to the state. That's a constitutional provision, but that's the general overview is that there's a duty to gain the greatest benefit to the state when leasing. And so preference specifically is given to applicants who are bona fide residents of Wyoming. They have to meet the other provisions that I very first talked about. So it's interesting, you have to be a bona fide resident of Wyoming and still a citizen of the United States. There's kind of two different standards there. But you have to have an actual and necessary use for the land. A preference is usually given to owners or leasees of adjoining lands, and the preference is given if you offer to pay an annual rent not less than the fair market value. And so if you do have a preferred right to renew, so there's a general preference, and then to have the preferred right, you have to be up on your rental payments and you have to meet the requirements as I've mentioned. And also what's important is you have a right to renew if you will meet the highest competing offer. If there's a conflicting application that has a higher offer for the lease that you've made, that you currently have, then you have to be able to match it, and then that gives you that preferred right to renew your lease. It can't be less than fair market value, the competing offer, and it can't be more than 120% of the max fair market value for that land, and that's determined by the Board of Land Commissioners. And they use also a formula that's based kind of on the National Agricultural Statistics Service, which utilizes things such as, the private land lease rate per animal unit month, private land, leasing amounts for private land on irrigated and non-irrigated cropland, and then there's usually a downward adjustment to account for leasee contributions to the land that is done so. Leasees are allowed to sublease, assign, or subcontract their lease if they get approval from the director of OSLI. They can't reasonably deny it if it still is a benefit to the state, but half of the excess rental has to be paid back to the state. And so then just addressing changes that were made by the House Bill 3 that was just passed, it'll become effective on July 1st. And this goes back to the way preference will be given. It still requires that an applicant who is looking to lease vacant state lands meets the previously discussed requirements. They have to have that actual necessary use of the land. They have to have the ability to gain access to the land, and they have to offer to pay an annual rent that is still in keeping with fair market value. And they cannot have violated any laws or regulations for leasing state lands. And so preference shall be given to an applicant who owns, currently leases, or lawfully occupies land that adjoins the land that is to be leased. The board can decide not to recognize a preference of an applicant for a showing of good cause. And preference will ultimately be governed by kind of three factors. It's still that requirement that a person who has preference to lease land has to elect to meet the highest bid of a competing bidder. If there are two applicants who are eligible for a preference, then the director of OSI will request a final bid from the two competing applicants in a manner the director chooses, and so that there can be a final determination about who will be awarded the lease. And then if there are two or more applicants who are eligible for preference and another applicant who is not eligible for a preference makes a higher bid, then the applicant with a preference can elect to match that higher bid, and the successful applicant will be decided by the directors. As previously outlined, there'll be that final bid process, but that's just getting into the nuance of meeting bids, and especially if you maintain a preference. Before any lease or application is accepted to lease vacant land, there is a notice requirement. The director of OSLI has to post it to their website, and they have to provide that information directly to any adjoining private landowner regarding that vacant land. If there is an applicant who would otherwise have preference, but the board does not recognize their preference for good cause, they have to provide a statement to that applicant explaining why, and they also give them notice that they can request a hearing to appeal the board's determination. And so throughout this, there are some definitions that are included in the changes by 2022 House Bill 3. Preference does just mean an applicant maintains an elevated position in the bidding process for leasing state lands. Vacant land is just any land that is not currently subject to a grazing or agricultural lease. And then a preferred right is to distinguish between a preference and applying to the lease of vacant land. And a preferred right is that the right to renew an existing lease if the old leasee is in compliance with the requirements of the requirements of leasing state land. Sorry. And in addition, under Statute 36.5.106, that was just actually related to the Richard Bridge Historical Park in Evansville, Wyoming, but there's also been the additional bill passed that restricts the use of state land around certain state institutions, specifically the State Veterans Cemetery and the Veterans Skilled Nursing Facility. Those lands, they have to be used for agricultural purpose, and they cannot be disposed of without permission. I'm sorry, I gotta say the right one here. Yes, can only be disposed of as long as those facilities still exist adjacent to the state lands. So as long as those two facilities, related to the Veterans Cemetery and the Skilled Nursing Facility, as long as they're there, those lands are very limited in what they can be used for. Yeah, and in the event of even rental offers, it's when two qualified applicants apply for and both offer to pay the same and highest rental rates without a pre-existing or preferred right to renew. The lease is awarded to the applicant who holds title to the land nearest to the land that's to be leased. If there is a preferred right, the leasee gets 15 days notice to exercise their preferred right to renew. And if they don't do so, then the land will be automatically awarded to the applicant offering the highest rent and who meets all the other criteria. 2022 House Bill 3 makes conforming changes to this section as well, but it is just to standardize the use of the term preferred right, which is when there's an old leasee who has the preferred right to renew the same land. Rents or rental payments are due for lease lands are due annually on the anniversary of the lease. And there's a process, if those go past it, there can be a late fee. If a lease is canceled for non-payment, the Office of State Lands and Investments is required to advertise that vacant land to be leased as soon as possible. And then another important piece to leasing is improvements on the land. Leasees maintain a right to make improvements under certain conditions. If per section you make an improvement that costs less than $2,000, you can just go and do that as a leasee of state land. If it's over $2,000, the director of OSLI has to approve per section for those that improvement that you're wishing to make. The director is limited to approving improvements for fencing, water development, livestock handling.
Would you hang on
range
just a minute,
enhancements. Yes.
Mr. Plum? We got a question here.
Yeah, just real quick, as you continue to explain that process, I don't know if you know or not, when's the last time we updated that $2,000 limit?
Chairman Eklund and Co-Chairman Boner. I do not know off the top of my head when that was last done. OSLI may be able to address that more clearly, but I could certainly find out when that was actually established. I just don't know right now. Yes, it is that $2,000 limit, and so yeah, there's certain things. If it's anything other than like those standard uses that the director would allow for, if it's going to be over that $2,000 limit, then it requires the leasee to get a special use permit. And if a leasee does not obtain permission to make improvements that are over $2,000, then that leasee can forfeit the right to any compensation that is allowed when there's a new leasee who would be using those improvements. Any improvements to leased land may be removed by the old leasee as long as there's care taken to minimize injury to the land, and they have to do it within 120 days after the expiration of their lease. There was a process.
Just hang on a second. So,
Absolutely.
committee, so you understand when there are improvements on the land, if you're the leasee and you want to improve and it's under $2,000, you can do it. If it's over $2,000, you take it to the board and make the request. Something we were just talking about is a possibility of changing that limit. I would guess $2,000 has changed in the last year just with inflation. It just costs a fortune to build anything anywhere. So we'll consider that maybe in a little bit here, but go ahead, Mr. Plum.
All right, thank you, Chairman. So there is compensation of improvements that are made to the land. Any future applicant of state lands who is awarded the lease and where there have been improvements made. Brad, when you first apply for it, you have to pay the regular filing fee, you have to pay the first year's rent, and then if there is improvements, then you have to pay the director of OSLI for the use and benefit of those improvements, that is essentially to go to the owner or maker of the improvement. And the cost of using the improvements is the contributory value of those improvements, which is the increased value of the property after the leasee's improvements are considered in the valuation of the land. And so the owner of an improvement is still allowed to remove those within that 120-day time frame if they notify the director of OSLI. And then just getting into it, there is a form for leasing that is to be prescribed by the board. Leases do not require a bond to be issued. And the board also maintains the authority to cancel leases when there is proper proof to show that there was fraud or deceit in receiving that lease, or if there's been any other violation of the covenants of the lease. And then in addition to the agricultural and grazing leases, the board can also lease state lands for industrial, commercial, or recreational purposes for terms of up to 75 years. And the board must consider compatible uses for the surface area of the state lands when they're going to give one of these long-term leases, and still the whole point is their duty to gain the greatest benefit to the state. But there can be no action that would otherwise substantively impair an existing lease or prefer right to renew land. And for those leases, the board is still required to set a rental value that is consistent with fair market value. And if a Laramie school district, or if a Wyoming school district intends to engage in a lease under the terms of this section, there's once again, the rental fee can be $100 per acre, or the fair market value of the land, whichever is less, but there is that specific provision for school districts. And the board is required to set rules and regulations for implementing these policies and procedures. And they have to consider planning, zoning, and all of those kind of things. Leases for industrial, commercial, or recreational purposes are not assignable without written consent of the board. And the liability of a state land leasee to the users of the land is limited to the liability that is outlined in Wyoming Statute 3419-101 through 107. And that just covers basically the liabilities of owners of land used for recreation purposes. And so it's just basically that using that same statutory scheme that's already in statute for liability. And it's slightly different for improvements, as the improvement, it's the same liability as long as the improvement was properly authorized by the board and that the leasee did not charge the user to use the improvement. And so that's just a general outline, a very quick overview of the general leasing provisions. Next, I can move into mineral leasings and hit on that quickly if the
Okay, let's
board would like.
see if there are any questions on.
Absolutely.
Okay, Senator Kolb. I don't know how to pronounce your name. You're new.
Kolb.
Welcome to
Thank
our
you.
committee.
Well, thank you, Mr. Co-Chairman. I just had a quick question, page 26. And it goes on, it starts off the paragraph, any applicant seeking to renew an existing lease shall have a preferred right to renew. Now, the lower part of that same paragraph, and it goes on to say, a bid offered by a qualified conflicting applicant provided that the bid to match not less than the minimum fair market value, nor more than 120% of the maximum fair market value as determined by the board based on previous year. Question is, how many times does that come up where people have run up to the maximum of 120% of a bid situation like that? Would you please expound on that? Thank you, Mr. Chairman.
Chairman Eklund and Senator Kolb, I don't know, to be honest. This is just a general overview of the statutory provisions. The Office of State Lands and Investments may have a better understanding of when they do run up against that. But I didn't look specifically into the current uses of it. This is just a statutory overview. So I'm sorry, I don't have the answer for you right now. Any further questions?
Okay, well, go ahead into the mineral side of it, please.
Excellent. So for mineral leasing, under the statutory provisions, the board can lease any state or school land for oil and gas production for a primary term of up to 10 years. And then they can continue it thereafter as long as there's oil and gas being produced in paying quantities. Then they can extend those if they're in good standing. And so the board is charged with and authorized to promulgate any rules and regulations necessary for leasing state land for oil and gas, natural gas, and coal production purposes.
All right,
And
Mr. Plum, hang on a minute. We got another question here. Representative Clausen.
Mr. Chairman, Mr. Plum, so it said the board can extend those up to 10 years if there's quantities that are worth going after. Is there a held by production clause in the states or in your research, or is that something for state lands? So if there's a small production, is that lease still held, or does the state have the authority to have some leniency in that, I guess?
Chairman Eklund and then Representative Clausen. The statutory provisions is just as long as it's in paying quantities. And so I think that's more under the rules and regulations, more so. Just the general statutory provision is just the term, as long as it's continuing in paying quantities.
Okay. All right, thank you. Go ahead.
The board is required to set terms for mineral lease rental payments either on a monthly or annual basis. And those will be annually applied against royalties that accrue for the same lease year. Royalties for land lease for oil and gas production are at no less than 5% of all production that is not otherwise saved and used for production operations. And royalty of not less than 5 cents per ton of coal produced from a mineral lease is the basis, and that is paid on a mine run. No mineral lease that is issued under these sections can be assigned or transferred without the permission of OSLI. They are separate and distinct from agricultural grazing leases on the same land. But the board is allowed to promulgate rules and regulations to allow for the joint use of specific state lands for both agricultural and grazing, as well as mineral leasing, as long as there's not an undue burden placed on any other or those classes of the state land leases. The director of OSLI is allowed to join with the United States and its lessees into equitable cooperative and unit plans for development, operation, and production of oil and gas. It's very similar for coal as well. If there are lands, there's federal exploratory units that is often associated with this, but it does give the director the power to enter into those. They can change the terms of the lease to meet those cooperative and unit plans. And if they're terminated, there's still further requirements that the lease be continued in effect for at least 2 years or for the term of the original lease, whichever is longer.
Okay, now we got another question. Go ahead, Representative Clausen.
Mr. Chairman, Mr. Plum, so when those go into federal exploratory units, it changes, in a private lease, it changes the terms of the lease. Is that the same? I saw a little quotation, but is that the same with the state? So the state could lease to a company, and then when it goes into a federal exploratory unit, it changes the terms of the lease to whatever the unit terms are. Is that consistent with private practice?
Chairman Eklund and Representative Clausen, I don't know if there's necessarily a requirement that it changes it, but the director is given a wide latitude to change the terms to meet the the plans, the unit plan that is there. So I think it kind of depends on the situation and when it comes up to when they're actually entering into those cooperative units with the U.S. government. But that is up to the direction of the board, or to the director of OSLI to make those changes so that it will conform. That makes sense.
Okay. Thank you. Continue on.
Absolutely. And so, yeah, as I mentioned, similar to joint cooperative and unit plans for oil and gas production, the board may approve cooperative mining development plans for its leases on behalf of the state. And it's very similar that the director of OSLI, under the criteria established by the board, may modify and change any terms of a coal and other minerals leases mutually agreed by the lessor and the lessees. So there is some give and take there that they have to work together. And all lands in a cooperative mining development plan should be under the effective control of a single operator. But in the terms of the coal and other mineral leases, the primary term for coal mineral leases are for up to 10 years. Coal leases have an exclusive right to renew their lease for excessive 10-year terms if they continue to meet the criteria at the time of filing their renewal application. And then kind of getting into another interesting point here, if a cooperative mining development plan is in place and the leasee is complying with the plan to actually produce coal or other minerals, the leasee is to be engaged in good faith development of the leased land. And they can have to show that to the satisfaction of OSLI, that the production has not been delayed or that they are continuing to develop the land. And so specifically the term good faith development is defined in statute as the substantial expenditures of or firm commitments for exploration, engineering, environmental studies, or research and development which is required for development of the lease. And there's a process that they can go through with the board to establish that they are in good faith development of the land. And the board can review those and bind the board and the parties, the leasees who are seeking to do so, that they are establishing good faith development. And the leasees are required to report all production, which includes total volume, value, and disposition of the produced minerals. Anybody who fails to do so can face penalties and potential cancellation of their lease.
Okay, we got another question.
Absolutely.
Representative Clausen.
Mr. Chairman, Mr. Plum, so in your research, was there ever a case where somebody was just sitting on state minerals, holding them as an asset, and the board dropped those, or is that common, or is that something for state lands maybe?
Chairman Eklund and Representative Clausen. It may be for state lands, they may know more so. I did do some look into case law. I only provided a couple in this memo because I just didn't find a ton I thought that was relevant to state land leasing specifically. And I did not run into a case where there was an issue with good faith development. I tried to look into that, but didn't find something. But OSLI may have more information on that.
Okay. We've got another question here. Representative Portner.
Thank you, Mr. Chairman. On these charts here, I don't see anything that deals with solar and wind. Is there any solar and wind projects that cross state lands? And if there is, where's that revenue at?
Chairman Eklund and Representative Fortner. Yeah, I agree, like wind, renewable energy, those kind of leases, that's not specifically included in statute, and I did just a brief overview look into that if there was anything in terms of case law, and I didn't find anything. I don't know if that's contained in the rules. This was more specifically into the statutory provisions of that, and so OSLI may know more so if they have a process for doing those types of leases, but no, that's not what I found in my research. Yes.
Okay. Chairman Boner.
Yeah, and that'll be covered in OSLI's presentation. It's not in statute, but it looks like they certainly have a process to deal with that. And we'll all learn what that is here soon.
Okay,
Any further questions?
continue on.
Okay, thank you. And so just continuing on, there is just more information that the board must require that subsurface log reports are submitted to the state geologist. Those reports are for anyone who is leased for coal, uranium, or other mineral exploration. They have to provide reports to the state. And existing oil and gas leases on state lands that were adopted prior to 1955 were ratified by statute. And much as it was under state land leasing for agricultural and grazing processes, compensation still must be provided for improvements on mineral lands. And it's in that same term as that. But improvements for mineral leases include machinery, equipment, development of the leased lands, but it doesn't include things like wells that do not produce oil or shafts that do not produce coal in commercial quantities. Counties, cities, and towns, as well as school districts, are allowed to lease any of their real property, and they can allow for the exploration, development, and production of oil and gas if their governing body determines it's in their best interest. So it is allowed at the more local level. It's similar to the structure of state land leasing, and it's the whole point of trying to determine what is in the best interest of that entity, and they have their own ability to do so. They can modify the terms of a lease if they are going to enter into a cooperative or unit plan agreement, and they can make and establish rules and regulations that are necessary to allow for mineral leasing. And then finally, just at the end, there is statutory sections that just allow for, it provides definitions for the calculations of royalties on oil, natural gas, and other associated mineral production. And no leasee or their successor on leased land, state lands, can deduct from their royalty obligation their return on investment costs. And this applies to all state leases of oil, natural gas, and associated natural resources. That's just a general overview of Chapter 6, which is the mineral leasing. Are there any further questions?
Questions, committee? Okay.
Excellent. And then just, if the committee would wish, I can briefly run through the case law and some of the approaches by other states. I identified two primary cases. The first one was Rydell v. Anderson, and that was a case from 2003. And this one was important because the Wyoming Supreme Court held that there was a statutory trust created by the state land leasing statutes. They determined there was not a federal or Wyoming or a trust created by the Wyoming Constitution for state lands, but they did determine that because there is this process and there is this requirement that it has to be in the greatest benefit of the state, that there is a statutory trust which creates the fiduciary duty by the state. The claimants here essentially had lost out on a state lease due to a preference. And so their claims were that that the state was breaching its duty to receive the fair market value for the land, that statutory construction of the preference statutes essentially amounted to an absolute right to renewal, and that granting privileges to those who use school lands was prohibited. The court disagreed with these claims. They essentially said that there was not sufficient evidence to show that there wasn't adequate income established by state land leasing, that they were going off the basis of fair market value, that someone who receives a preference does not undervalue the land because old leasees are still required to match higher bids for land. And so ultimately, the state did not violate any fiduciary duty on the statutory trust lands because it was following the statutory provisions for preference. And then in that same vein, the second case was Office of State Lands and Investments versus Mule Shoe Ranch, and that was from 2011. And this one was different. In the first case, the person who challenged was not the old leasee, but someone who was trying to take over that lease. In this instance, the old leasee challenged a requirement that they had to meet that higher bid because OSLI did not conduct an economic analysis and didn't base it on fair market value. But the court ruled that the statutory scheme related to state land leasing did not preclude OSLI and the board from considering higher bids, and it can be different than what is established by their formula that they use, and that's within its rules and on how it's calculated. And so the court determined that the board was authorized to accept the higher of the two competing bids, and that it was still meeting its fiduciary duty to gain the greatest benefit to the state.
Okay, Chairman Boner.
Thank you, Mr. Chairman. Thank you, Mr. Plum. And so in your review of the case law, I guess I'm thinking back, we've seen a couple veto letters that cite Article 18, Section 3 of the Constitution, just pointing out that the Board of Land Commissioners does have the authority to, direction, control, leasing, disposal of lands. Also says in these veto letters, never seem to acknowledge the other part of that sentence, which requires they do it under the direction of the legislature. So in your review of the case, has there been anything that has ever undermined the legislature's ability to pass a law to direct the manner in which these lands will be managed?
Chairman Eklund and then Co-Chairman Boner, looking at this, it was primarily that it wasn't directed so much as like there was a limitation on the legislator's ability to create, to by statute, regulate state land leasing. I didn't find anything specifically on that point. The court has held that the statutory scheme for which state land leasing is conducted is valid, that within that statutory scheme, certainly things like, the right to renewal and, the preference and having to meet those higher bids are all valid. But I did not find any case law that directly was on point as to the constitutional ability of the legislator to prescribe by statute for state land leasing.
Yeah, follow up.
Just in case it's unclear, in fact, I mean, the cases you cited, that was challenged in the court case, and the court found that we did in fact have that authority. Is that correct?
Chairman Eklund and Co-Chairman Boner, it didn't specifically say that the legislature has the ability to do so. That wasn't necessarily mentioned because this was much more so in terms of, are the statutes constitutional? And so it was kind of that, I guess, you can kind of make that step. That wasn't how the court ultimately decided it. They just essentially were saying the statutory scheme is appropriate and that there is no problem if that's how state land leasing operates.
Okay. Thank you. Continue on.
Okay. And next, I just went through several different states. Just very briefly, I looked through some of their processes for how they handle state land leasing. Right off the bat, and I think even as Mr. Wilmarth had mentioned, almost all states use their state land leasing processes and disposal of state lands for the benefit of public schools. And so just to quickly run through these, I did look at Colorado, Idaho, Montana, Nebraska, South Dakota, and Utah, as they are our surrounding states. And like in Colorado, their leasing is still primarily handled by the State Board of Land Commissioners. Their renewal process is slightly different, as an old leasee essentially gets to negotiate with the board to come to terms to renew, and if they can't meet on those terms, then the land is just open for the next person to apply for it. They do allow, I guess, generally by statute, allow for more categories of leases than Wyoming. There's agriculture, but they allow for commercial real estate, ecosystem services. There is mining, oil and gas, but they also allow for recreation and specifically renewable energy, water, and those types of things. And so it's just a little more expansive in kind of how they decide those things in statute. And in Idaho, similar to the structure in Wyoming, the Board of Land Commissioners, they appoint a director of state lands, and they also have categories in addition to grazing, agriculture purposes. They do allow for recreation home sites, commercial buildings, and those types of things. And renewal is handled by the Department of Lands. 2 or more bids goes to an auction to grant a lease if they are competing in that fashion. Montana, very much like Wyoming, does have their Board of Land Commissioners, which is comprised of their 5 top elected statewide officials. Theirs is managed by their Department of Natural Resources and Conservation's Trust Lands Management Division. They have a similar renewal process. The old leasee has preference. You can meet the higher bid of an applicant who does not have preference, and they do allow for real estate leasing, but it's very similar in structure to the state of Wyoming. Nebraska is somewhat different. Their state land leasing process is very specifically to benefit its public schools. It's actually handled by the Board of Education Land and Funds. This board has sweeping authority to manage state lands. It's appointed by the governor with the consent of the legislature, and their primary uses are for agricultural, mineral, and renewable energy purposes. And the board gets to determine rental values. They're guided by fair market value, but they can set lease terms. Some are set in statute, but it's really, this board has pretty sweeping power to maintain that. South Dakota they have their state land leasing administered by the Office of the Commissioner of School and Public Lands. They say state lands may be leased primarily for agriculture purposes with 5-year terms, but it's also statutorily authorized. So they they kind of have it in both places, that is in the Constitution and in statute. And they do give old leasees renewal rights. They can submit an application prior to the expiration of their old lease. And this is somewhat different because they can do it without advertising, to essentially say, if you submit your application, you're pretty much guaranteed a chance at the renewal. And their mineral leasing is handled very similarly. That one is specifically found in statute, and they still have that preferential right to renew or even purchase the land they operate on. And the last one that I addressed was Utah. They have their own, it's a fairly recent establishment, but they have the School and Institutional Lands Administration, Trust Lands Administration. And their primary purpose is to provide endowments for education in the state. And so they're managed by a board of trustees who also appoints a director to administer the state lands. And they will do leases for things like renewable energy, commercial telecommunications purposes and those types of things. But that's just a quick overview of the different states and some of their processes. It's fairly similar, just different boards that are handled, and sometimes they have broader statutory categories for state land leasing. That was the general takeaway there. And then just at the end of this paper, if you wish, I could briefly run through here, but I did just provide this chart that just goes through and discusses a couple of the recently enacted bills that I touched on. 2022 House Bill 3, 2022 House Bill 17 was the one. Veterans facilities are required to be surrounded by agriculture and grazing purposes, and they can't be disposed of as long as those facilities are still in operation. But then there are several other bills that have been considered or by both houses and for different purposes. There is some that I included here that deal with the land exchange process. But then just generally, these are just to provide a little information about where there is some legislation, where it's been going in recent years. I can go through that in more detail, or I'm open to any other further
Committee, any
questions.
questions? Okay, well, thank you. That was quite a little bit of information. Good job.
Well, thank you.
So we're ready for public comment. Is there any, I'd have one more question. I'm not sure it was answered or that I understood. I think Representative Clausen started into it. So if we have, this is specific to the mineral leasing on state lands. If we have some state lands that have, the minerals were developed maybe 20 to 50 years ago, and they've still got stripper wells on these things. Does the leasing of that, is it affected now that here we are, fast forward 50 years, and you've got drilling blocks that could be 3 miles long? Are the state lands bound to hold the lease on stripper for leases that have stripper wells on the sections if there's new technology and they can better develop minerals another way, or does it have to be developed by that leasee holder? We have that circumstance, I know, and the potential for quite a bit more mineral development in certain areas.
Absolutely, Chairman Eklund, and to the committee as well. In terms of mineral leasing, there has to be good faith development of the land to continue to make sure that there is that, and that's a process that can be accomplished through the board. Leases can be continued, I guess, in the statutory construction. Leases can be continued if they are still, producing and paying quantities. And so it's a lot of that is left up to rule and regulation of the board and as established by OSLI as far as I understand that. But statutorily, there just has to be that good faith development, and that's a separate process. But once again, that's not even clearly outlined in statute. That's primarily left up to rule and regulation of the board.
Okay. Yeah, Senator French.
Yeah, just a kind of a follow-up along your lines. It says in there that in any mineral royalties will be not less than 5%. What are the current rates if somebody wants to lease minerals, oil and gas on state land? Because I know private individuals are getting 12.5%. I've heard it's bumped up to some cases 18%. Do you have any idea?
Chairman Eklund and Senator French, I don't know. This was primarily, that was what is in statute, and that was what my overview in this paper was. I'm sure, yeah, I think the department, OSLI, may be able to answer that information, or I'd be happy to look into it further if needed.
Okay. Well, thank you, sir. Is there going to be public comment on this section that we've just gone through? All right, nobody in the public, any further things from? Okay, I think this is a good time for a break. We'll take about a 10-minute break, and then we'll start in with Office of State Lands. Get my button on. The meeting will come back to order. The next order for our business is Office of State Lands. And you can go ahead and start up when you're ready.
Sure. Thank you, Mr. Chairman. I'm Jennifer Scoggin, the Director for the Office of State Lands and Investments. And with me today is Deputy Director Jason Crowder. We were asked to provide the committee with kind of an overview of state lands and then to kind of get into some of our revenue generation activities. So we put together a PowerPoint. It's behind tab 1 of your materials. We'll start with that. Feel free to ask questions as we go along. And if at the end we haven't covered things that the committee would like to discuss further, we're happy to entertain any and all questions.
Okay.
Okay, so next slide. So when we talk about state trust lands, the first word that comes to my mind is impact. State trust lands have a significant impact on this state. In the past 5 years, trust lands have generated over $910 million. 89% of that, or about $810 million, has directly funded K through 12 education. Our state trust lands, unlike any other in the nation, have the capacity to serve the children and the citizens of the state for many generations to come, and we at OSLI are incredibly proud to be part of this important legacy. So let's get into some of the trust land basics. The first thing I'd like to do is talk about our mission statement. In my time at OSLI, I've come to realize that not many people really understand what trust lands are or what OSLI is. Our mission statement is effectively managing natural resources and funds for current and future generations. And as we get into the slideshow here, you'll see why that is. So next slide. So we'll start with a quick US history lesson. You may have heard some of this from the gentleman with LSO prior to us, but following the American Revolutionary War, Congress began preparing for a unified nation of states. And it was believed that free public education was essential to a successful democracy. So in recognition that new states did not really have a tax base from which to fund schools, Congress looked for ways to provide folks a method to be on equal footing. And that would help compensate for the inequity. So they did this by granting the territories fee title to portions of the federal estate for the purpose of supporting public schools. To ensure the lands would remain a viable resource for supporting public education, Congress then mandated that the territories agree that those lands be reserved for the maintenance of public schools. And management of these lands has been repeatedly interpreted as a trust by both federal and state courts. And what's required to manage these lands has changed over time. In the 19th century, lands that were granted to the states were the primary source for support for public schools, were relatively subject to the unfettered disposal by the states. They made a solemn promise to manage the states for public education, but the reality is the requirements on them were much less than what happened later on. As more states joined the Union, the federal government became more prescriptive with respect to what states could do. So next slide, please. So the first state to participate to receive the federal grants at statehood was Ohio in 1802, and nearly every state to join the Union after Ohio received trust land. The most recent was Alaska in 1958. And so this is a map of states that received trust lands at statehood, though not all still have them today. Some states that originally received trust lands, like Kansas, sold off their trust lands and then invested the funds for K through 12 public education.
So I've got a question down that lines. How well has that worked out to sell the lands, pocket the money, and then watch the lands go skyrocketing in price?
Chairman Eklund, I think it's mixed. I haven't specifically researched Ohio and Kansas to see, but it's my understanding that a lot of scholars have concluded that it's probably a little better to keep the lands and generate revenue off of those lands. There's more opportunity as opposed to just strictly selling lands and investing those funds. But I don't know. Jason, do you have an opinion on that?
Mr. Chairman, I think it's a great question and something that should be analyzed regularly. One of the real estate principles that we abide by is that one of the greatest hedges against inflation is to maintain real estate, to be able to create revenue off of the income that's derived off of those based on the current market rates, obviously keeps pace with inflation in large part. And so maintaining your land ownership in comparison to investments does that for us.
Yeah, Senator Boner.
Yeah, Mr. Chair, maybe a good way of thinking about that is, if there's ever been a calculation on the return on investment of our state lands, which you'd have to kind of come up with the valuation of all of 3.9 million acres and compare that to the investment we get, return on investment we get, say, with the permanent land funds, either for the permanent land fund or permanent common school land fund, and it should be a relatively easy, comparison. If you just have a good ROI on the state land portion, we know exactly what it is for our investments. And by our Constitution, I think we learned whenever you sell something, it goes into the permanent land fund, or common school permanent land fund. So in my mind, that'd be a relatively simple calculation from our end, but then again, you want a good balanced portfolio too.
Yeah, I would agree that Wyoming has probably done it in a wise fashion. Sometimes I compare it to selling the calf crop. Sometimes I'll sell the calves and I think I was probably safer owning the calves than I am the money that I got out of it. But I think Wyoming's managed it well, and constitutionally we have to maintain a certain plus or minus acres. As we sell some, we have to get more land, correct?
Mr. Chairman, we'll get into a little bit of that further into the presentation.
All right, go ahead.
So quickly, today there are 23 remaining states. We collectively manage a total of 156 million surface acres and 177 million subsurface acres. Next slide. So with respect to Wyoming, prior to Wyoming becoming a state, the Wyoming Organic Act was approved by Congress on July 25th, 1868, to provide a temporary government for the territory of Wyoming. Section 14 of the Organic Act provides that sections numbered 16 and 36 in each township in the territory are reserved for the purpose of being applied to public schools in the state or states thereafter that would be formed out of the territory. Next slide. So then from September 2nd, 1889 to September 30th, 1889, a constitutional convention met in Cheyenne where the Wyoming Constitution was framed. The Constitution was ratified by the Wyoming voters on November 5th of 1889. The Constitution also addresses state school lands. Under Article 7, all monies arising from the sale or lease of school lands are perpetual funds, and only the annual income from those funds can be appropriated. All funds belonging to the state for public school purposes is deemed trust funds in the care of the state, which are kept for exclusive benefit of the public schools, and income from the perpetual funds, and all rents from unsold school lands shall be exclusively applied to the support of schools in every county in the state. Next slide. So how are trust funds administered? The Wyoming State Constitution and the Wyoming Legislature direct the Board of Land Commissioners to manage the trust assets. You'll see in Article 18, Section 1, the state of Wyoming accepted the grant of lands made by the U.S. to the state for educational purposes and for public buildings and institutions, and the conditions and limits that could be imposed by Congress. It also created the Board of Land Commissioners. Wyoming Constitution, Article 18, Section 3, provides that the Board of Land Commissioners shall have direction, control, and disposition and care of all lands granted to the state of Wyoming. So importantly, as stated earlier, the state trust lands are owned by the state and held in a trust for the benefit of public education in the state and other state institutions. Next slide. So who are the Board of Land Commissioners? The Board of Land Commissioners is comprised of the 5 top electeds in the state: the governor, the secretary of state, the auditor, the treasurer, and the superintendent of public instruction. Again, they're constitutionally charged with optimizing revenue from state trust lands to support public education and those beneficiary institutions, while concurrently striving to protect, conserve, and maintain the lands so that they may be used by future generations. Next slide. The Constitution also has a role for the legislature. Article 18, Section 4 provides that the legislature enacts the necessary laws for the sale, disposal, leasing, or care of all lands granted to the state, and the legislature passes laws for suitable safekeeping, transfer, and disbursement of land grant funds. Next slide, please. So then came the Act of Admission. The Wyoming Act of Admission provided for the admission of the state of Wyoming into the Union. It was approved on July 10th, 1890, which also ratified the Wyoming Constitution. The Wyoming Act of Admission again addresses the granting of school lands. It grants, again, Section 16 and 36 of each township to the state for maintaining common schools. And it also granted to Wyoming certain lands for the support of certain institutions such as the University of Wyoming, the Veterans Home, and the State Hospital. The Organic Act also specifies that school lands can only be disposed of at public auction, and it provides that the legislature has the power to regulate leasing of lands so long as the term of agricultural and grazing leases do not exceed 10 years. Next slide. So there's also a statutory framework that governs the board and OSLI and what we do. Statute 36-2107A provides the authority for the Board of Land Commissioners to promulgate and adopt rules and regulations necessary for direction, control, disposition, and care of all state lands, and to preserve the value of the land and to recognize the fiduciary duties of the State Land Office. Next slide. And I won't go into each of the statutes, but here's some other principles that arise through statute, and that's that state trust land shall be managed under a total asset management policy. State land trust is intergenerational and must be managed with a focus on protecting the corpus for the long term. Trust land should remain a substantial component of the trust portfolio. All leases shall provide a fair market value return, considering the lessee's management practices and risk. And investment policies must protect the permanent land fund from the effects of inflation. Next slide. Administration. The administrative arm of the Board of Land Commissioners is the Office of State Lands and Investments. It's our responsibility to carry out the policy directives from the Board of Land Commissioners. And just as an aside, we are also the administrative arm for the State Loan and Investment Board, and we carry out their directives too, largely related to state grants and loans. But we won't get into that today. We're just talking about trust land management. So next slide, please. So this slide provides sort of a summary of who exactly the trust land beneficiaries are. As I mentioned, we're mainly working for funding Wyoming public education, K through 12 schools, but there is a list there of some of the other institutions that are beneficiaries of state lands. So what are the trust assets? We have 3.4 million surface acres. We manage 3.9 million mineral acres, and then there is the state permanent land fund, in which the majority of revenues collected from the trust lands are deposited. In that fund, there's over 4.5 billion. Next slide. So this is a map showing the state of Wyoming's trust lands. They're all highlighted in blue, and as you can see, this is a considerable asset for our agency to manage. Next slide. There's also, the trust asset also includes several ranches, which are managed by the Board of Land Commissioners, and those are indicated by the stars on the map. Next slide. So the how, what do we do to generate revenue on state trust lands? This is sort of a bullet pointed list of the things we do. Grazing and agricultural leasing, which is self-explanatory. We also provide easements, which give legal authority and recordable easements across state trust lands. We generally utilize those for pipelines, power lines, roads, that sort of thing. We also have temporary use permits. Those are short-term authority for various activities on state lands, such as construction staging areas, stockpiling sites, and some organized recreational activities. Then we have special use leasing. These are more the long-term leases to provide economic benefit through competitive commercial, recreational, and industrial leasing. These leases are used for commercial activities, things like cabin sites, secondary oil and gas activities. We also work on land sales, exchanges, and acquisitions to optimize opportunities that provide the state trust land ownership patterns that are more conducive to effective and efficient management, increase in land values, increased income generation potential, and greater public access are all things that we consider in those activities. We do have some renewable leasing, largely wind energy. We have recently, I believe, been approached about a potential solar lease, so we're working through that. Then, of course, we do mineral leasing, which is oil and gas, coal, trona, all those sorts of things. And then our forestry division helps us with forest product sales for those timbered lands that are state lands. We're always searching for new ways and opportunities for compatible uses on state trust lands and to generate more revenue. Next slide.
Director,
Yes.
so getting back to the wind leasing, we had that question earlier. The revenues for a wind farm that were put on state lands would go into the school foundation account, or how does that work? Or have we even done it? I'm not even sure state lands have been affected by it.
Mr. Chairman, we do have several wind projects on state lands. Jason, are you going to give the breakdown of the revenue for that in the revenue discussion? Okay. Mr. Chairman, I'm sorry, we don't have those specific revenue figures with us, but we can certainly provide that to the committee this afternoon.
Okay, thank you.
Okay, in preparing for our presentation today, Chairman Boner asked that we provide to the committee kind of an overview of our leasing and permitting processes. So the next probably 10 or so slides are some flow charts that summarize sort of at a high level our process for these aspects of management activities that we just went over. So as you have an opportunity, some of these you've seen before, such as the exchange process. But we tried to just sort of capture sort of high level those aspects and processes that we go through when we get an application for this sort of activity on state lands. Go ahead. Just because you want to get back to the oil and gas leasing slide, just because we had some questions about oil and gas leasing, or I guess the previous speaker did, I just thought I would quickly go through our oil and gas lease. It is a 5-year primary term. Our royalty rate is 16 2/3%, which is reduced to 12.5% if the lease is not successfully, or if the lease is not let, if you will, in the first auction. We do offer our leases competitively through an online bidding process with EnergyNet. We do have some stipulations on our oil and gas leases, largely to address sage-grouse executive order and mitigation corridors, things of that nature. We try to do that on a case-by-case basis and not just blanket stipulations. There is a surface impact payment component for impacts of the oil and gas activity on state lands as they may impact other lessees. Oil and gas activities may also require additional surface permitting through the agency, such as using temporary use permits for construction or special use leasing for other sorts of facilities. And we have a table that's on the right-hand side of that slide, which kind of shows you a comparison of the oil and gas royalty rates, at least in some neighboring states.
Okay, we got a question. Representative Fortner.
Thank you, Mr. Chairman. Is that 16.75% royalty rate, is that competitive with the private sector, or are you guys lower than what the private sector is out there? I know that there's a lot of school sections that get produced before private mineral gets produced. I think that ought to be, the competitiveness ought to be the same right there. I don't think the state should be lower than the average landowner, the guy that actually owns his mineral, his royalties. I think they should be running neck and neck. I don't think the state ought to be cheaper.
Jason, do you want to answer that?
Mr. Chairman, Representative Fortner, it's a great question and one that we discuss a lot because we want to do exactly that. We want to be competitive and generate the revenue that we're owed, the appropriate amount of revenue. Finding that private land royalty rate has been problematic. Those are negotiated on a lease-by-lease basis. There's no standard private royalty rate across the state, and it's specific to the regions or the different basins, producible basins across the state. So for us to be able to understand exactly what each private land lease rate is, that's been an answer we can't find. The best we can come up with is to have a collaborative conversation with industry, with those fee owners, those fee mineral owners, as well as their organizations like PAW, and try to determine what a good economical royalty rate is on state trust land development, understanding some of the other parameters that they have to pay, like surface impact payments and those. So to answer your question, we don't have a good sense of what that private royalty rate is, and if there's a good place for that information, we would readily absorb it and use it.
Okay, Representative Clausen.
Mr. Chairman, Representative Fortner, so I do represent the #1 oil producing county in the state of Wyoming, and I can tell you straight up that 18¾ is generally the minimum and up to 22 for private leases.
Okay. Yeah, Senator Boner. Oh, Representative Heiner.
Thank you, Mr. Chairman. Director, have we had any oil and gas lease sales this year, or are we contemplating having some later this year? And what are the lease bonuses coming in at?
Mr. Chairman, Representative Heiner, we did have a lease sale back in March that was actually very successful. We're starting to see leasing come back. We are planning another oil and gas lease sale July 6th through 13th, so 13, excuse me. So we do have some planned and on the books. We did see a significant decrease in leasing activity and interest, as you might imagine, during the COVID, when we had negative oil prices and all of those things. Another trend, one of the trends we're starting to see now, which is giving us hope too, is the last Board of Land Commissioners meeting, which was last Thursday. We're seeing a number of existing leaseholders who are seeking extensions and that sort of thing. They want to hold on to the leases instead of just letting them go, which again also gives us hope. The last lease sale, Jason, monetarily, 2.6 million, and it had been as low as what, a couple $100,000 in 2019 and 2020. So we're very encouraged, and we think that things are turning around and coming back.
Okay, Representative Clausen.
Thank you, Mr. Chairman. Director, so it seems our system is a bit antiquated for the changes in oil and gas. Currently, you know, when all this stuff was set up, it was 160-acre spacings. Now we're up to, well, technology's there for 3 full sections, 2 sections pretty standard. A whole bunch of things have changed as far as how the business aspect of the industry works. Do you guys employ, say, pancake pew clauses, anything of that nature? And do you have a held by production, a way to get out of held by production, and a way to terminate leases if people are just sitting on them, using them as an asset, releasing them, those sort of things? Do you guys have those sort of methodologies in your contracts?
Mr. Chairman, Representative Clausen, we do have some of those things in our oil and gas leases. And we have had instances where, you know, we become aware of folks wanting to maybe preserve the what's going on the surface and keep it undisturbed, and so they'll want to apply for an oil and gas lease as a way to hold that. When we find out about those things, we generally do not issue those leases if we find out that that is going on. We're trying to come up with other ways to address people's concerns about the surface, such as perhaps conservation leasing and things of that matter, to address folks' concern with wildlife and that sort of thing. Director or Deputy Director Crowder, what am I missing here?
I'm not sure that you missed much, ma'am, but I'd also add that those statutes and rules are relatively old, and they haven't kept up with technology, and technology has moved really quickly, and it's a spot that we could pay some attention to create some ease in our office of trying to use an antiquated statute to a current technologically advanced situation. Some of those things that you speak about really get complicated when we start talking about units. And the committee did speak to units earlier, but when we are operating in a unit scenario, we have some provisions within statute that create an administrative nightmare for us internally. So you can imagine that the mineral estate is from relatively the surface down to the center of the earth. But units speak to specific unitized substances or specific unitized areas, which could be a subset of that depth, leaving the rest of the depth open and outside of the unit provisions. Our statutes and our rules kind of put us in a bad spot as far as being able to manage something deeper than a specific unitized area or something shallower than a specific unitized area. So that's an area that we could pay more attention to and would be happy to have those conversations. The other thing, sorry, Representative Clausen, was that when we start talking about longer laterals, we start discussing many royalty or mineral owners that are not just the state. And a lot of times those are federal, and in some cases they're fee and many fee owners. However, some of the structure, because we are a process-driven entity and not really I don't want to say a passion-driven entity as a fee owner would be, or somebody who owns a surf and is trying to make a whole living off of the surface, that a lot of that infrastructure does get placed on state lands. However, we can't allow other minerals to be produced from that surface location because our lease and our rules are very specific to that parcel. You have the quiet enjoyment of that development of that parcel and nobody else's. And so then we start tacking on more fees, more rentals, and that becomes, in cases, anyway, it's been expressed to us, in cases where that becomes too much of a burden for a particular developer to absorb all at once. And so those are things that we could pay more attention to and try to bring the statutes and rules up to current standards.
Follow up?
Thank you, Mr. Chairman. So I'm just seeing lots and lots of antiquated things. Do you have a process in which, so the name of the game, and it's changed a little bit, was to just tie up acreage and then go to the stock market and borrow, say you have prove one well and you have so many drillable acres, and then just sit on that and basically use it as an asset and not produce? Do you have held by production standards? Do you have any way of getting rid of those sort of things? Have you ever, I won't say you personally, but the agency, has it ever been executed? Just because we can doesn't mean we ever did. Those are sort of some of the things I mean, when we look for like our report from school, our staff that takes care of school funding, we're seriously seeing diminished returns in this area, and not, I would say, exponential diminished returns. And I think a lot of that is because of our antiquated system. So are we looking in those areas, or are we just kind of charging on with 1970s rules?
Mr. Chairman, Representative Clausen, another great question. I think it's probably a little bit of both. I will say that we have a performance measure within all of our mineral leases that if you don't produce or you're not actively pursuing production, you don't get to hold the lease forever. Specific to oil and gas leases, they're given a 5-year primary term, and if they don't produce within that first 5 years, they can ask the board for 1-year incremental extensions for another 5 years. The board's rules are very specific in how those extensions can be requested and for what purposes. They're not just for holding on to them. You have to be actively showing or be showing movement towards production, or show areas where you've been harmed and by the federal government or some other government regulation or some other surface lessee or surface owner negotiation that you can't get there. Those are reasons that the board can approve extensions. But you're given that 5-year primary term, and if you don't produce within that, then you don't get the lease any longer if you can't prove that. The other part of it is if you start production and paying quantities, and for whatever reason, the whole lease, not just a well, but a whole lease needs to stop production, you need to request what we call a suspension of operations from the Board of Land Commissioners, and that's very specific as well. You have to have good reason and good cause to stop producing, otherwise you would lose your lease and you'd have the expectation to reclaim and we could let it again. But also in that, it doesn't come for free. So each suspension that's approved by the board gets a ratcheted per acre rental rate up to $40 per acre. So the whole process is really driven to get those producers in a producing mindset and to not have them just sit on a lease going forward.
Go ahead. Representative Heiner.
Thank you, Mr. Chairman. Director and Deputy Director, as I look at this chart you have for oil and gas royalty rates that you're displaying here, you've got Wyoming pretty close to the bottom. And yet, as I look at those states, they're kind of ranked by the amount of oil and gas that they're producing. And, you know, Texas, of course, is one of the biggest and most producing most of the oil and gas, and Colorado, New Mexico. I would guess that we as Wyoming, as our oil production ranks comparatively with these other states, we should be 4 or 5 points above where we're at right now. It seems like we're artificially low in our royalty rates, and I wonder if we ought to revisit that and see if we can get more revenue for the state from our oil and gas production, because Wyoming does have great resources. But to let our resources go at a depressed value is probably not the most fiscally responsible thing that we could do right now. Do you think that we should revisit that? And I see your tiered approach. Other states are not doing that, but maybe the tiered approach should be, if we keep doing that, maybe we ought to raise that up a little bit higher, royalty rates. What are your thoughts?
Mr. Chairman, Representative Heiner, certainly that's something that's on our list of things to explore with the Board of Land Commissioners. They set the royalty rate in rule, correct? And we, you know, with the recent increases in federal royalty rates and things like that, so it's certainly something that we definitely want to look at. We also want to visit with PAW and the industry before we do something dramatic, but certainly that's on our list of to-dos, if you will, with respect to reevaluating revenue and revenue generation on state trust lands.
Mr. Chairman, just to add to that a little bit, in the prelim analysis that we've done related to this, because when we look at this graph, this is not where we'd like the state of Wyoming to be either. But we have to look at the whole state structure globally, not just state land royalties. And when we pull everything in, we start seeing the severance tax rate pop in. And I don't have that graph and I don't remember it precisely for you right now, but we have one of the highest severance tax rates of anybody else as well. So the initial analysis anyway shows that we might be equal as far as total revenue from oil and gas development, maybe not just on state lands, but statewide when you bring in the severance tax component as well.
Senator Boner.
Thank you, Mr. Chairman. I think that's a good point why, you know, for the private raise between 18 and 20, it's, well, it turns out about 6% lower than Texas, which doesn't have a 6% severance tax. So I think that's a good point. But nevertheless, the royalty rate is a little bit low compared to the private sector by about 1 or 2% by my estimation. I understand that's certainly larger than the statutory minimum of 5%, but not quite the market rate, but that's determined by the board. Certainly something we can consider though with when you build your house we have moving forward. But I think Representative Fortner had a very good point, and that's, you know, that anecdotal experience in Converse County as well as Campbell County. You know, you have an oil and gas pound in every last school section. And when that development happens within the context of what is almost exclusively private land outside that school section, it points very strongly that the rates are lower than the market rate. And that's not just bonus payments. Actually, I think Representative Heiner had a very good point with it. Our process for bonus payments seems to be very good and market driven. Obviously, the royalty rate is artificially set by the board, and I have concerns about the damage payments to the surface for whether it be roads, pipelines, for the pad itself. You know, generally there's a price per acre or per rod that you get if you're the private landowner in order to access that private property. And so I agree that state lands doesn't always have a good idea of what the market rate is, but that ag leaseholder does. Correct me if I'm wrong, but it wasn't too long ago where we rely a little bit more heavily on that ag and grazing leaseholder to negotiate on behalf of the state, since they know exactly what the market rate is because they're negotiating the rest of the development outside of that school section. And so my question is, long lead up to it, but the question is, how do we rely on that rancher, the ag leaseholder, to negotiate on behalf of the state? How's that changed recently? And what are we doing to leverage that private sector knowledge so that state lands isn't stuck with this impossible task of trying to find the market rate in every last school section in the whole state?
Mr. Chairman, Mr. Co-Chair, you're exactly correct. There's no way for our office to understand each parcel and the appropriate rate for each one on each specific use. So when the Split Estate Act was enacted, we created rules that allowed the surface lessee to negotiate on the state's behalf all of those specific uses or the impacts those uses would have to their operations. That has not changed. That still remains in effect today. How people are using it may have changed throughout the years in that we're getting a lot more sophisticated landowners that are coming together as groups and negotiating those rates rather than just one individual grazing lessee at a time. So that's been a positive and a move in the right direction as far as ensuring that market rates are derived not just on the private land, but on the state land as well. There are two caveats with it. One is in our temporary use permit rules, and then the other is within our easement rules. Those are specifically set by the board, and those aren't negotiated, and those are the only deviations. But when we are talking about roads for oil and gas development, we're talking about oil pads or tank batteries or pipelines or anything like that. All of those are negotiated by the surface lessee and the entity entering that property. The one thing that has also occurred since the Split Estate Act is that while the surface lessee does negotiate that, they don't receive 100% of that payment. We have a split with them depending on how much that is. Some going back to the board and some staying with the lessee.
Yeah, follow up.
Is that process set by statute or is it in your rules?
Mr. Chairman, Mr. Co-Chair, that's set by rule.
Okay. Representative Western, did you still have a question? Been answered.
Mr. Chairman, Senator Boner asked my question. Thank you.
Okay. Representative Clausen.
Mr. Chairman, Director, so the other surface damage aspects are negotiated by the leasee, but could you breeze just a little bit on water disposals and how that process has evolved and maybe some rule?
Mr. Chairman, Representative Clausen, yes. That process for surface impact payments is set by rule, and it is negotiated because it's done under the vehicle of a special use lease. It's not an easement or a temporary use permit. So that is negotiated on a case by case. And water impoundment structures or water treatment facilities have grown exponentially in the last few years as water recycling has become important in areas where there's not a lot of water and the technology is advanced. So we're seeing those sites become larger and larger, but the surface impact payments are set by negotiation.
Yeah. Follow up.
Mr. Chairman, Director, so are those based on a fair market value or are those negotiated through your office, or what are the basis of those uses, fees?
Mr. Chairman, Representative Clausen, I'm assuming you're talking about rental fees now. Those are negotiated with the applicant to some extent, and then whatever comparable market rates we can also apply, we pull that into the equation. So if we can find information that might tell us how much those are being sold for or rented for on private or federal lands or other state lands, then we utilize that information. If we can't find that, then the board's rules do allow us to go back to a bare minimum of $250 or 5.5% of the appraised value of the land. And we can use that as a starting point. But we also work really hard with the applicant who's bringing the activity so that we can fully understand the impact. And if there's something that's similar to a water treatment facility, something that may have as much traffic in and out, may utilize the same amount of acreage as far as impact, then we can use that as a comparable as well.
Okay, Senator Kolb.
Thank you, Mr. Co-Chair. Director, do you do an analysis on the royalty rate after a bid to see if it's appropriate? We got 16 2/3 say we're going to start off at. say it goes for 16 and thirds royalty rate, if I understand this correctly, after this happens, do you look at adjoining properties and analyze if that was fair or not, or do we have to adjust that rate on the royalty rate? What, is there any analysis done after this point of a royalty bid letting?
Mr. Chairman, Senator Kolb, there is not a separate post-lease, if you will, analysis. All the leases are set at 16 and 2/3%. If it doesn't go in the public auction the first time, then it can be reoffered at 12.5, but we don't do a specific site-by-site analysis to determine if that's sort of, if something should be different in the area. It's just in that 16 and 2/3, like I said, that's set by the Board of Land Commissioners.
Follow up. And on that note, is there a prohibition about going at a higher rate? And then you said you have, if it doesn't go at the 16 2/3, it would go back out again at the 12. Could you go higher than that, step it down? I mean, could you have a tiered system where you would let it go 2 or 3 times? Let the market drive the royalty rate that people are willing to pay. Thank you.
Mr. Chairman, Senator Kolb, I don't believe there's a prohibition to doing that. I think it would just require a rule change and an analysis by the Board of Land Commissioners to codify that in some way, and I don't think they're opposed to that. I think it's just a matter of trying to figure out a process to do that. And again, noting sort of the antiquated nature of our rules and some of our procedures right now. Certainly that's something that we're going to be looking at, but appreciate your suggestion.
Down this line. Okay, yeah. Representative Clausen.
Thank you, Mr. Chairman. So do we have the information of how many actually producing wells we have out at 12 3/4? Because it seems like there's a little room for gamesmanship with our antiquated system. If everybody says, you take this one and I'll take this one, and we'll just drive her down to 12 3/4, leaves a little room for the state to maybe miss out on some revenue for schools. Do we have that information and how much production is actually at that rate?
Mr. Chairman, Representative Clausen, we can get that information for you. I don't have it at my fingertips right here, but we can certainly provide that to you.
Okay, so I'd add a little bit because I've been involved in something similar to this. Pretty much in this area, just northeast of here, there's a well field, and to negotiate the lease, and some of them have to be renewed because they don't get them drilled out in time in a certain block and area. There's a balancing act between royalty rates, what's too high and what's too little. If it's too high, so in this area, the highest I've heard of was 30%, and not an acre was leased under that. The oil companies couldn't make any money on it. It's been lowered and it still isn't being leased. In another area, maybe down to 12, but most of it that I've heard of is around 16%. And that land, if it's up for lease, usually is leased, and or within an area. I think some of what Representative Clausen and Boner have talked about is an area where they have pretty much proven hot areas where if you get the lease on it and drill, you'll probably get a well. They have the formulas and the technology to get oil. But I can only imagine how difficult it is for the Board of Land Commissioners to determine what the lease is. When myself, I know that they're probably anywhere from 12 to maybe 25%. 25 never gets leased in this area, and even the 12% is tied up by the 25%. So that's, anyway, I'm sure you'll persist in trying to get the state a pretty good deal. I'm not sure it's artificially low. I think it's just hard to figure the number, the appropriate number. So committee, okay, can we move on and continue? Thank you. All right, go ahead.
Okay. We'll get the slideshow back up here, Mr. Chairman.
All right.
Okay, so when the agency evaluates a course of action with trust lands, we follow what are known as the trust land management objectives. There are 3 trust land management objectives which are provided by statute. The Board of Land Commissioner has sort of ranked these from highest to lowest. A proposal doesn't need to meet all of the trust land management objectives, but we'll go through the management objectives in order from highest to lowest. The first one is to better meet the beneficiary's short and/or long-term objectives. And you generally see this in the form of revenue. We look to improve income-generating potential. It could be by itself or perhaps other state lands needs a bigger block, and that assists with that. It could be single or multiple uses. We also look at investment value. Can we improve returns? Can we diversify the portfolio? Does this piece of property have appreciation potential? Are we improving our natural resource values, habitat, water, those sorts of things? The next management objective is to improve the manageability of the land asset. So we look and see, is this going to help us, like for instance, in an exchange or acquisition? Is it going to help consolidate ownership patterns, maybe block up some lands, which makes it easier to manage? Can we leverage resources of other agencies, such as maybe state parks or game and fish? And then the third objective is to meet a specific school and/or community need. If there are ways we can improve community stability, provide growth opportunities, or improve access for hunting and other recreational opportunities. So those are the 3 management objectives that the legislature has told us to look at when we're dealing with opportunities for state lands. So this is our management paradigm, and usually when I give this presentation, I highlight, if you don't get anything else out of it, this is the slide to pay attention to, because we find that there's a lot of misunderstanding with respect to what state trust lands are and what OSLI is. So this slide just highlights that state trust lands are not the same as public lands, and OSLI is not the same as BLM or the Forest Service. Federal agencies manage public lands in a way to balance a wide variety of uses, including energy development, livestock, grazing, recreation, wildlife conservation. They're also trying to ensure natural, cultural, and historic resources that they're maintained for present and future uses. Conversely, state lands are managed with consistent trust principles, long-term growth and value, and optimum sustainable revenue production. So a little bit of a difference with respect to the purpose of public lands versus state lands. Next slide, please. The other thing we get a lot of questions about, we thought we'd put in the presentation a couple slides about recreation. The Board of Land Commissioners rules and regulations set forth the narrow recreation privilege granted to use state lands. The board extends to the public the privilege of using legally accessible state lands for casual day uses. It's allowed when it will not result in damage to the state land or the roads and improvements on the state land. Organized, developed, or commercial recreation use of state lands is prohibited unless it occurs under some sort of special use lease or a temporary use lease. Next slide, please. So recreational uses on state lands are somewhat limited. They include hunting, fishing, casual day recreation, such as horseback riding, hiking, photography, wildlife observation. Notably, camping is not allowed. Motorized vehicle use must be confined to established roads. And if the board feels that state lands are being abused, they can close them. Misuses of state lands are considered to be a misdemeanor. And I'll let you know, just in my experience, the board takes closure very seriously. They don't close lands just to close lands. It's got to be something really egregious that's going on, and they can't find any other solution to preserve the trust asset. So they don't just randomly close sections.
Okay, Director, we've got a question here. Representative Worf.
Thank you, Mr. Chairman. Director, I was here, I remember when we took away the ability to camp on state lands. And we did that because of abuses that were occurring on those lands. It was reported there was a lot of like mud bogging and stuff that was going on that was causing damage. I know in a prior life, I represented sportsmen, and I know one of the things we were trying to work with was kind of going to date myself, but it was back when Ryan Lance was in your position. And one of the things we were trying to do was to get, there were some kind of key areas that we lost camping that was kind of essential or pretty crucial for some of the places, just because of the lay of the land. There wasn't a lot of places that people could camp. And so they were places that weren't necessarily being damaged. They had been historically used, but that was all lost in one fell swoop. And one of the things we were trying to do is set up some type of a program where those areas camping could be reinstituted. And it would be kind of like, you know, you see on the highway where you have people that kind of adopt that mile. Because I know one of the things they talked about was one of the problems was nobody was picking up the trash. And we don't want to see our state trashed, but one of the things we were working with Ryan on was to try to come up with kind of like an adopt a campground where the state land board didn't have to do that, but you could maybe have a community, whether it's a sportsman's organization or some other entity that would be willing to do that. We could put up a sign that says, you know, these people are responsible for cleanup, and they would have the obligation, responsibility to make sure that trash was removed. But I would really like to see that picked up, because we supported that. I know as sportsmen, we don't want to see our state lands trashed, but I do think we bought in and supported it, and now it's maybe time to be looking at where that can be instituted in a manner that allows the use to be there, but to also cover kind of the potential for abuse. But I would definitely ask you to start working along that. I'd be willing to work with you on bringing up a bill to set up a process. But I would like to see us revisit the prohibition of camping across the board. I think there are some areas where it's warranted and where it probably would be very beneficial for the people that live in the state. So, you know, and maybe look at how we would do that.
I wasn't aware that it was across the board, but you can go ahead and fill us in on that.
Mr. Chairman, there are some limited camping opportunities authorized with exclusive outfitting, I believe. But for the most part, camping is not permissible. As you can imagine, with the vast number of surface acres we have, it's kind of hard to police all of that. And that's our other sort of issue, is we don't have law enforcement authority, so we would have to work with Game and Fish and state parks. Doesn't mean we can't, doesn't mean we shouldn't look at it, and certainly we're happy to dust that off and to continue, to look at it. But I know that there have been concerns about, you know, the fire hazard and all of that with drought going on too. But certainly if this is something that that you would like to work on, we'd be happy to dialogue with you on that. And I'm sure your interactions with former Director Lance is before my time, so I don't know all of the ins and outs of that. Deputy Crowder, do you have any thoughts?
Mr. Chairman, you're correct. We went through an extensive effort with the Game and Fish Department to identify those areas that have historically been used and may not have exposed grazing lessees or others to a lot of harm, and could they continue to be used. We identified 10 different areas that fit that mold and looked at them extensively. And I think that the conversation with the Game and Fish Department stopped largely with the enforcement piece, because we didn't have the idea of having a group or somebody else who would be responsible totally set up at that time. You needed the enforcement piece of the stick as well, and they were limited in providing that to us. We also had a small task force, if you will, put together with the state Secretary of State and the state auditor probably about 6 years ago. And we sat down for about 6 months at the direction of the Board of Land Commissioners to try to answer this question as well. After we came up with all the details, I think we largely came up with the same answer, that not only do you need the support from some type of interested group, but you need the enforcement piece as well. And to be honest, I don't know exactly where those conversations stopped, but those were the tenor of the conversation there toward the end, is how do we bring Game and Fish or somebody else onto the enforcement side?
Okay.
Thank you, Mr. Chairman. And I guess I look at it, you know, you can always find obstacles. And I guess I look at it, we got to find the solution, because it's not satisfactory to me that we just say, well, we can't do it because of this. I do think there's options that are there, and I would like to visit with you and come up with a way to do it, because I really want to make it clear, I'm not looking to say you can go willy-nilly camp wherever the heck you want to, but it is problematic that we provide that for outfitters and we don't provide it for the sportsmen that are not kind of licensed outfitters. I think that's a disservice to a lot of the sportsmen. And so I would like to visit with you maybe a little bit more, see if we can't pick that back up and come up with a way to do that. Because I look at, we have all these areas in the state where we pick up trash along the highways, and I do think people would be willing to step up and say, we'll adopt that. But we got to create that avenue. And, you know, the bottom line is, I think if you have that process in place, I think we can find that solution. Because law enforcement, to me, that's just something they got to do anyway. And I know when you start with a clean area, it's a lot easier to keep it clean if you got somebody watching it. I've had to clean up areas where people have just been dumping trash. We picked up tons and tons of trash. But I do know, working with law enforcement, that once you've got it cleaned up, which it should be clean now, to implement that process, it's a lot easier, because you can start to identify who's leaving the trash. The problem comes when you're picking up a problem where there's trash all over. But I do think it's workable, and I would ask you to continue to work on that. So,
All right, Representative Larson.
Mr. Chairman, thank you. So has there been some discussion with the state parks on maybe picking up some areas or such?
Mr. Chairman, Representative Larson, not recently. However, as I mentioned to Representative Worf, I think that's something we can and we should do. I would be happy in our conversations, maybe we can get both Director Nesvik from Game and Fish and Director Westby, and the four of us work through some of this and dust off what was done previously and see what else might be possible.
Good. Okay, well, go ahead.
Okay, next slide, please. So let's talk a little bit about Trustland earnings. What comprises the money earned from state lands? 86% of the trust lands are classified as common school or state sections. Probably most people have heard of that. 14% are those lands that generate revenue for institutions. Internally, we call them institutional lands. Grazing is the most prevalent on state trust lands, with approximately, we manage 4,000 grazing leases covering about 98% of our trust land surface acres. And so therefore, we obviously rely heavily on our grazing lessees to help us manage this surface asset. And mineral development, as you might imagine, generates the most income for the state trust land beneficiaries. Next slide. At this point, Mr. Chairman, I'm going to turn it over to Deputy Crowder. He's going to take the committee through some of the revenue numbers from the past 5 years.
Thank you, Mr. Chairman. As you can see, and as the committee noted earlier in the previous presentations, we've had a steady decline in revenue derived off of state trust lands for the last 5 years, and 6 years really the year that's dropped off of this 5-year comparison. That's attributable to a lot of things, but the most recent just aggressive decline, obviously, is the pandemic, oil and gas development on state lands, coal production on state lands, and trona production on state lands. And all of those have come together at the same time to provide us with historically low revenue numbers as portrayed in this graph. The one bright spot, obviously, is the projected fiscal year 2022 revenue numbers. We're expecting to be closer to on par with fiscal year 2020, and that's largely due, and in fact, if not totally due, to the rebound in the oil and gas market. Obviously, we're experiencing market prices that are higher than we have in the last 2 to 3 years, and those are becoming more stable. A lot of folks weren't participating in our oil and gas lease auctions, as was referenced earlier, because of the instability. That viewpoint or that future perspective is looking a bit more positive, meaning that we're getting a lot more interest in our oil and gas lease sales, which obviously leads to more production and more drilling on state trust lands, which we're realizing creates more revenue from that. One of the, sorry.
Yeah, we got a question. Representative Heiner.
Thank you, Mr. Chairman. Deputy Director, the revenue is increasing, but could you give us an indication what the production is like? Are we seeing increased production on state lands, or is it flat or declining?
Mr. Chairman, Representative Heiner, that's a great question, and we can provide that information for you. That's an extremely complicated graph that our royalty auditors put together for us, and we can provide that information for you. One of the reasons for the steady decline over time are some things that the committee is very much aware of, and that's a lot of federal regulation. Obviously, the moratorium on coal leasing has an impact on state coal leasing. We don't have new leases coming on board, which adjacent state leases suffer from, and so a lot of that coal remains trapped in the ground, and we're not able to produce.
Representative Ward.
Thank you, Mr. Chairman. Deputy Director, can the state actually capture what those losses are so that we can actually articulate to the federal government what the policies, how those policies has harmed our state? I guess for future actions, I really get frustrated. I'm sure everybody here gets frustrated with some of the actions that have taken place with various administrations. It does seem like to me that our state economy has been under attack for under several different administrations. I would like to see the state start to capture what those losses are so that we can put that kind of in as an arrow in our quiver so that we can start to fight back. I mean, I'm tired of allowing the federal government to do things that I believe are outside its enumerated powers, and I think this state needs to start challenging that and being able to document how that is impacting our economy and how that trickles down and affects our education and everything else that it does. But is that something that you guys can help us kind of capture?
Mr. Chairman, absolutely, and we work closely with the state geologist as well to have known amounts of material down there that could be produced, and then we can apply some future projected value of that product and provide that to you. I think the other prong to that as well is not only are there no leases available, but the market, where can you sell this product, is extremely limited and becoming more limited as we go forward. So it's a couple different ways to look at the same problem. But we see the impact in these graphs from those problems. The other thing you all are very much aware of is the state ownership is very much a shotgun pattern. It's 16 and 36s largely, and we don't have a lot of contiguous land when these mines are going in place, specifically coal and trona. And we've not done a lot of land transactions, and sometimes the federal government retained the coal through different land transactions. So we're subject to when a mine is on state land and when a mine is off of state land. So another piece of this perfect storm is both coal, while it's declining in its amount of production, is not adjacent really to a lot of state lands that we're accustomed to seeing. Generally, that's a $30 to $50 million per year revenue stream for us that has been less than $1 million here lately, or anywhere from that $1 million to $10 million range, which really has a significant impact on these graphs. And so it's important to note that while markets play a role in this, places to sell plays a role in this, and the adjacent leasing environment plays a role in this. You have to actually be mining state land, and that plays a huge role in this. One other important note, and I'll go to the next slide to kind of make it.
We got a follow-up.
Follow-up. I just was wondering, I know at one point, I know that the state was trying to do some land exchanges to block up so that we could develop some of the trace minerals in the state. Can you kind of tell us, is that something that the state is continuing to kind of to pursue? And is that something that we're also facing? You know, we always talk about coal and the oil and gas, but are the trace minerals also being impacted by some of the federal regulations that the state's incurring, or that the nation is, I should say?
And Mr. Chairman, Representative Wharf, that's another good question. And we are actively pursuing any trace minerals that somebody would like to develop, and happy to have those conversations. The efforts that we've taken most aggressively in the past were to do some land shifting to ensure that there was a tailings pile site that could be available for these folks. So we actually exchanged out of that because we didn't want to own some possibly environmental hazardous site, and allowed the beneficiaries to acquire a piece of property that had much more revenue generating potential and a lot less environmental hazard potential going forward. But we've looked at lithium development. We've looked at a variety of trace mineral, going all the way to gold, precious metals as well, of that kind of development on state trust lands. And really we're subject to who can develop it and if they can make that economically feasible going forward. But we're happy and stand ready and have the leasing vehicles available for that.
Okay. Go ahead.
And Mr. Chairman, just to kind of give it a little more granularity to the revenue numbers, this graph shows the breakdown between mineral revenue, other state trust land revenue, timber, and miscellaneous. And as you can see, the mineral really tells the story on why we're moving forward. And again, to the point that was raised earlier, this isn't necessarily a policy issue within the state or the state land office. It's simply what are the market values realized from oil and gas development, and when are we mining coal and trona off of our lands? And again, the perfect storm has occurred to have this continually decline. The other trust land revenue, that's where all of our surface leases are housed, our grazing leases, our special use leases, and you can see those are on a continual decline as well. And a large part of that is tied to the grazing lease rate and the formula that derives that rate. Since 2014, we've been on a continual decline in our AUM fee, and that's based on that formula. A large part of that is based on the amount of money it costs for a producer to actually produce a pound of beef, and we call that the parity ratio, and that has increased over time. And as those increases occur, the formula feels the impact of that by a reduced outcome. And within the materials, Mr. Chairman, I could point you to how all that is derived that we provided to you. But in 2014, the highest rate we have ever experienced was $6.46 per AUM, and we've continued to see that decline based on the formula, and the outcome of the inputs from the National Agricultural Statistics Service has played on that. With the exception of next year, we are realizing that that parity ratio is adjusting or normalizing to a flat rate. And then we're also seeing that private lease rates are increasing, which has an impact on the state grazing fee. And so it's increasing by 10 cents next year. So we've hit the bottom for this cycle anyway at $5.24 per AUM, and next year it'll be $5.34 per AUM. Mr. Chairman, I'm happy to answer any questions on that level of our revenue analysis.
Okay, committee, looks like you can continue on.
Mr. Chairman, the next graph is more of a pie-shaped graph to kind of tell you the same thing that the bar graphs were showing you. You can see where the trust land leases lie as far as their percentage of the total that come in. And again, this is specific to the surface use. Happy to answer any questions on it.
Go ahead and continue with your presentation. It looks like we're good.
Well, Mr. Chairman, I'd just highlight the fiscal year '21 revenue from the mineral leasing side of the shop, and total revenue was $100 million. 85% of that was from the minerals, and of that 64 million was from oil and gas development.
Yeah, Representative Heiner.
Thank you, Mr. Chairman. Deputy Director, in one of the slides we saw from one of the previous presenters, I saw that bentonite mineral leases had dropped almost 50% from last year to this year. Is there a reason why it went down almost $400,000 on the bentonite?
Mr. Chairman, I don't know if I can provide the exact reason, but it's subject to the same pressures that coal and trona are. You're either mining a piece of state land or you're not. And it could be simply that they've moved off of a piece of state land to somewhere else, but I'm happy to dig more into that and try to understand it. You know, bentonite revenue to us is less than 1% of the whole, and we do it, but we don't pay as much attention to it as oil and gas or coal or trona.
Continue on. Is that it? Do we, so that's probably, oh, go ahead, Representative Clausen. I think we're kind of at the end of a block here. We'll have some questions.
Mr. Chairman, and maybe this isn't, if this is under your preview, but would you go back, and I saw it in your slides, and just give us, I think I have a pretty good understanding, would you just give us a review, a run through of the land exchange program? We've had some, we had some legislation last year that got vetoed, and there are a lot of issues around that. If you could just give, so the committee has a quick review.
Mr. Chairman, if you'll give us a second, we'll get to the flow chart that sets forth our exchange process.
Is that in our notebook?
Yeah, yes, Mr. Chairman, you can find it either in the 101 presentation that we're providing right now, or we do have some information in the book on our current exchanges. You know what tab that's behind? Let me see if I can find it. Tab 6. So just to provide a quick overview of our exchange process, essentially what happens is we may have an applicant that's interested in doing an exchange with OSLI. And so the applicant may come in and have some informal discussions with staff about, you know, here's what I'm thinking. Is this something that state lands might be interested in? They have some further back and forth talking, maybe some maps or exchanged meetings, that sort of thing. Then they might or might not get to the point of what we call a Category 1 or initial review. And that's the time in which our staff takes all the information, drills down on it, and sees, is this something that would be in the best interest of the trust beneficiaries? And remember the 3 trust land management objectives that we talked about. Our initial review team looks at the proposed exchange through that lens and through those trust land management objectives. If they think it's a good deal for the trust beneficiaries, or they think it's going to help with some of those management objectives like blocking up land or increasing potential revenue generation opportunities, they think it should move forward. They then bring that to the director, and we call it then that's the Category 2 phase. And what they do is they do an initial review team presentation where they present to the director sort of all the initial review pieces and how they think it meets the trust land management objectives or how it doesn't, or, you know, this isn't worth putting the time and resources to that, or maybe it is. Then at that point, if after the director reviews she agrees that, yes, this should move forward, then a detailed analysis is prepared by the staff. And then they really sort of get into the numbers and the pros and cons, if you will, of the proposal. Then the detailed analysis is presented to the Board of Land Commissioners in an executive session in which we provide all the information, values, how this meets the trust land management objectives, why we think this should move forward. Then the Board of Land Commissioners will, they can't obviously vote in executive session, but they'll tell us, yeah, this seems interesting to us. Or no, this really isn't interesting to us. If it's not interesting, then we push it off to the side and we don't evaluate it. If it is interesting, they direct us to bring it to them in their next public meeting. And so we prepare a board matter and bring it as a walk-in matter. And in the public meeting, then we explain the proposal, why we think that this is interesting. And if the board decides that that is the way they want to go, they will vote on a resolution authorizing us to initiate an exchange. And like I said, that's all done in a public meeting. If in fact they tell the staff to move forward with the agreement to initiate exchange, we then negotiate. It's essentially like it's a real estate purchase agreement sort of with an option sort of component to it. It's sort of a hybrid agreement. We negotiate that with the applicant, assuming we are able to do that. Then we publish the detailed analysis to the public. We go through a public hearing and written public comment period, 60 days, I believe. We notify the county commissioners in the county where the proposed transaction is occurring, and then they help us further get the word out. We advertise in the local newspaper. We also push it out on our Gov delivery system to let people know that there's a hearing and that we're accepting public comment for 60 days. And then we bring it back to the board in another public meeting, and the board makes their final decision in the meeting to continue to pursue or not. And if they direct us to pursue, we close on the property. But there's also an opportunity for the board, based on the public comment period and all of that, to say, nah, maybe we don't really want to do this after all. Deputy, what am I missing? I think that sort of outlines the process in a nutshell. So there's two sort of public components, the public hearing, written comment, but there's also the public piece in the initial meeting of the board, wherein after the executive session, we bring it as a walk-in matter. And at that point, it's published to the public.
Okay, Representative Clausen.
Mr. Chairman, Director, so do we have policy as a state if somebody, say, is trying to circumvent paying surface damages and using land exchanges and that sort of nonsense? Is there official policy, or is that taken on like case by case?
We have our Representative Clausen, could you give me a little more detail? I think I understand the question, but I want to make sure. I'm sorry, Mr. Chairman.
Let's say, for instance, if I knew I was going to do some sort of heavy industrial thing on the state land, and I knew I was going to have to pay a sizable surface damage, and instead I just put in for a land exchange to trade for somewhere else. Do we have policy on something like that, or would that be taken case to case, or is that something that no one's thought of?
Mr. Chairman, Representative Clausen, that does happen. That gets proposed to us, not regularly, but often enough. And there's not a policy related to it. We are managing trust lands on a case-by-case situation from that viewpoint. And in the past, when that's occurred, we not only look at the impact payment that they might have to pay, and we look at it as a revenue stream to the state, but also what could that use generate as far as rentals or maybe royalties to the state as well. And we don't necessarily move on transactions, and we've denied a couple in the past that they would ultimately end up owning that piece of property, put that fantastic industrial use on there, and then we wouldn't receive any royalty. We just get the value of the land. And we've recognized that and have stopped those transactions.
All right. Senator Boner.
Okay, and committee will have some public testimony along those lines with a particular land exchange between Laramie and Commerce County, which I'm deeply concerned about, but we'll save that for a different time. So more broad question for you, Director. You went over the state lands portion, what you do. Could you just give us a brief overview of everything else that the Director of the Office of State Lands and Investments does? I know you obviously have lots of lands and loans and grants you administer, as well as you interact with the Oil and Gas Commission. And I'll just be very upfront about my concerns. It seems like this office is saddled with a whole lot of responsibility, and seem to be falling behind on the administration of state lands and minerals, which is causing some issues. So just a brief overview with that context of everything else that you have to do as director.
Mr. Chairman, Mr. Co-Chairman, yes, we do have quite a bit of responsibility. On our, well, let me give you a visual, if you will. So the Office of State Lands and Investments, we have different divisions. One that you're familiar with is the Trustland Management Division, which takes care of all the things that we just talked about. We also have the Field Services Division, and that's linked to Trustland Management. They're looking at everything from weed and pest to appraisals to inspecting state lands, all of it, the GIS systems. That's what that division handles. The Forestry Division is also part of OSLI, and State Forester Crapser largely handles the forestry issues, and then we have our Financial and Administrative Services Division, and that division is comprised of our Royalty Compliance section, and so those folks track and address all of the royalty payments associated with mineral development on state lands. We also have our Administrative Services section. They deal with the financial aspects of the agency. They also administer, excuse me, many of the Forestry Division grants, and they address all the reporting that goes with that. And then we have our Grants and Loans section, and they administer the various state grants and loan programs that are overseen by the State Loan and Investment Board, which again are the top 5 elected officials. They also take care of all the reporting requirements, like to EPA for the State Revolving Fund loans. They also do the reports to the legislature on the other grant loans, from the CAPCON to the ag loans to the student dormitory loans to all of that. So we're a bit of a diverse agency. And Mr. Chairman and Mr. Co-Chairman, we do have a lot of responsibility. We are torn in a number of different directions. We're also very lean. And so obviously, if it were up to me, we would have more folks in the Trust Land Management Division, just because right now we have one person program managers. So we have one person managing all of the ag leasing, which that can be overwhelming. And so we try to bring other people in to help when it really gets busy. We have one person temporary use permit managers. We have one person special use lease managers. What would really be helpful is if we had even a policy person that could take care of such things as the Sage-Grouse Mitigation Bank program. Jason, Deputy Director and I are largely running that. Also, we're now dealing with pore space leasing and that sort of thing. And so it would be nice to have somebody sort of in a bit of that role too, as a policy person, and then maybe somebody else that could help with the grazing and the other programs as they get busy and experience, when they're just sort of buried in the paperwork and we're trying to get it all pushed out in an efficient manner.
Good. Follow-up.
And what's the nature of your work in the Oil and Gas Conservation Commission?
Mr. Chairman, Mr. Co-Chairman, I'm sorry, I apologize, but yes, in my role as Director of State Lands, I'm also the acting chairman, if you will, of the Wyoming Oil and Gas Conservation Commission, and so that does take up a bit of time too. Those are monthly commission meetings up in Casper with the commission, and so yes, I'm running that and staying on top of those issues as well. I think I've covered it.
All right. Representative Fortner.
Thank you, Mr. Chairman. I think I missed the boat there earlier, but anyways, I want to walk back a little bit and find out what the cost of educating a student in Wyoming is. What can you give us that cost?
Mr. Chairman, Representative Fortner, I do not have that cost at the tip of my fingers. Would LSO, perchance, did you guys do that research? No? We can get that to you. We'll find that out.
Yeah. Last I heard it was maybe 18,000, but it's probably gone up since then. Well, depends on the size of the school and classroom size and stuff too, but I was thinking the average was 18. Now, okay. Wrong people to ask though. Okay. So, you're on a different slide.
Is there a slide on that?
How much longer is your presentation going to
Oh,
last?
Mr. Chairman, that concludes our State
Okay.
Lands 101 presentation.
All right, are we good with questions? Because we've got some public comment coming up. All right, you guys stay close. We'll probably may need to bring you back up. So
Thank you, Mr. Chairman.
Yes, thank you. How many people are here for public comment that will be testifying? I'm not sure how we'll manage the time, but is there any of you that can't come after lunch in case we have to break before? Yes, there are.
2 or 3 people from Congress.
Okay. Anyone that can't come after lunch? Will come if we break. We'll try to get her done. Maybe one. Go ahead.
Yeah, Mr. Chairman, what I might suggest, we have folks who came down from Commerce County area, maybe they can come down now. We can, so we just make sure that we get them in before lunch, and then we can, I know Mr. McGagnon wants to testify as well, but assuming you're going to be here all day, sir, so we'll, usually we go lobbyists first, but in this case, since we're running, closer to lunch, I think it's important we hear from the public about now, so.
Okay. Who would like to go first from Converse County? Come on up. Give us your name and you push hard. It's kind of a.
Thank you,
There
Chairman
you are.
Eklund and Chairman Boner, other committee members. Thank you for the opportunity to offer testimony today. My name is John Lehman. I'm a fourth-generation rancher in Converse County. His family's been in the ranching business for about 140 years. I'm also a precinct man for Converse County 7-7. The purpose of my testimony today is to express my deep and grave concern of how the Office of State Lands' use of unwritten policies and procedures is and has detrimental consequences to the private citizens such as myself who are making every effort to follow the process as the written rules, policies, and procedures prescribe. And what I'm prepared to share with you this morning was from a sworn testimony in a contested case hearing that involved vacant state leases. The administrative ruling in this particular case was in part the precursor to the legislation that came before you this past budget session, which was signed into law as House Bill 3, or the Vacant Lands Bill. And so I do appreciate everyone's attention to that particular bill. Therefore, I would respectfully ask that this committee at least launch an audit into the case, in this particular case, and reinstate the recommended order as prescribed by the Office of Administrative Hearings. And the facts of this case are as follows. My case involved 2 state parcels that were declared vacant by the Office of State Lands and Investments for non-payment back in 2001. And they remained vacant for 10 years, generating absolutely no revenue for the state trust fund. I was able to secure lands, the deeded lands in which one of these parcels was fenced. In October of 2010, that's when I began inquiring to the office, can I go ahead and lease this parcel that's fenced with me along with another vacant lease? The particular lease that I was interested in was, as I said, fenced in with lands that I owned and controlled, and had been assigned to that particular landowner for about 70 years. In essence, it made sense because of how the land laid with regard to the with regard to the deeded lands, and it made sense. So I asked the office if I could lease them, and they told me that there was a process. And the process was, we have to inspect them, we have to advertise them, and then you can get an application. No exception. I said, well, very good. They said, but because of staff demands and other priorities, we may not be able to get to it till sometime in 2011. I said, well, in light of that, could I make the non-payments? And they said, no, absolutely not. We have a process. They have to be inspected, they have to be advertised, and then you get an application, period. Okay. But they said, because you inquired about these state leases, your name will be put in the file, and if anything happens to them, you will be notified. Very good. So for the next 8 years, I made every attempt to get the office to engage in the process that they were required to do, or at least it was spelled out to me. And I got the same response. We don't have the staff, and it's not a priority. And I was even transparent, and I say, look, and I'm kicking my livestock on the deeded portions. They're grazing on the vacant parcel because it's fenced in with it. It has historically been assigned. Didn't make any difference. So testimony revealed in the OSLI over the 8-year inquiry was basically bending to the demands of a non-adjoining landowner to 1-8710, who wanted to be kept informed as to the status of both vacant parcels because they frankly wanted them. So with the assistance of the office, they created a model. And this model included the issuance of a temporary use permit for the specific purpose of grazing. And in this one temporary use permit, they included both vacant parcels. The one in which this was fenced in with myself, as well as the vacant parcel that was fenced in with this non-adjoining landowner to 1-8710. The OSI devoted and prioritized staff, time, and resources to this TUP on an annual basis for 8 consecutive years. And this, according to the deputy director, said that you can't speculate as to why it originally went into the temporary use permit. He also said, in fact, the rules specifically state to no to that particular type of use. And he further said to me that, quote, this should have never gone on as long as it had. So for the 8 years, I, along with a qualified adjoining landowner to 1-8710, were denied, in essence, discriminated against in participating in the adopted written rules, policies, and procedures as required to bid on the vacant parcel 1-8710. The willful and purposeful decision of the office to extend preferential treatment to a non-adjoining applicant through the modeling of a TUP, quite frankly, violated their own rules, and the prioritization of staff and resources resulted in securing for the state school trust fund much less than what could have otherwise been generated if the OSLI simply followed the process as required. They essentially defrauded the very trust fund to which this OSLI is required statutorily and constitutionally to secure the most revenue possible. At least that's what I've been told, is what the function of the OSLI is. It was further revealed that once this non-adjoining landowner did indeed become the new qualified adjoining landowner, it was amazing how quickly this office engaged in the required process of inspection, advertisement, and taking applications for both vacant parcels. It's also important to note that the case in this testimony showed that the new adjoining landowner willfully and submitted on the TUPs, board-approved forms, and the 10-year application form false information as is specifically related to 1-8710. They stated in there that this lease that was fenced in with me was actually fenced in with them. They were using it for grazing, and they would fence it if necessary. All total misrepresentation, period. And despite the written rules clearly stating in Chapter 4, in Grazing and Agricultural Leasing, Section 5, Applications, subsection A, on forms, all applications to lease lands for grazing or agricultural purposes shall be made on forms furnished by the office. Application forms must be completed in full. Any false or incomplete statements willfully made that materially affects the application will be considered as fraud, deceit, or misrepresentation and should be cause for rejection of the application. Despite all this, the OSLI exercised its own interpretation of the rules and determined that both the TUP and the application issue were immaterial, and this had absolutely no bearing in this case. The facts of this case were presented, evidence submitted, and arguments made by the OSLI and the two applicants to Office of Administrative Hearings. The very process by which the private citizens, such as myself, are supposed to go through in the event of gross negligence on the part of a state agency. The allegations were such that we won the case fair and square, and the process was trying to work. It actually was working. Yet despite the private citizens such as myself going through the proper process, following the rules, policies, and procedures, it was once again usurped, this time by a majority of Board of the Land Commissioners who overruled the recommended Office of Administration's order awarding the lease to myself. This even despite being reminded by one of the sitting board members that, hey, Lehman did go through the process and you won the case. Made no difference. And this brings me to my final real concern. For 6 years, these actions were recommended by an acting director of the Office of State Lands and Investments. These were recommended decisions to a board of elected representatives holding the highest positions in Wyoming, and they were all improved. What is very concerning and dangerous in this particular case is really the very sacred principle of the due process, to which each private citizen granted and is granted by the Constitution. I spoke to another sitting board member trying to get my head wrapped around what the heck happened here. And I had 3 questions for the sitting board member. The first question was, who do you deem credible in a case such as this? And the response from that board member was, I don't consider the Office of Administrative Hearings examiner to be even a judge. You simply dismiss the whole process, their own process by which people like me are supposed to go through if we have a grievance with a state agency that's clearly gone off the rails. Okay, my follow-up question to this board member was, if you don't deem your own process credible, then who do you deem credible and from whom do you take direction in rendering a decision in this particular case, in this instance? And the response from that board member was, well, I take my direction from the OSLI as well as from the Attorney General. Now, why is that important? It's important for the following reason. Because my follow-up question to this individual was, with all due respect, in this instance, and in this case, when you have a former state land director who for 6 years of the 8 years recommends these decisions to a board of elected representatives, which were clearly in violation of written rules and engagement of a whole host of unwritten policies and procedures, and this same individual now is appointed by a senior member of the State Land Board to now become the new Attorney General. And it's that individual's office who is now representing the Office of State Lands and Investments, who, by the way, through hearing, accuses me of being the trespasser, the violator, the bad actor, when all I was trying to do is say, hey, are you office going to do the job with which you're charged? Are you going to come out and inspect this thing? Do you find in that instance that that same individual whose office is representing you and directly advising you as board members in how to rule in this case, that you don't have a major conflict of interest and potential ethics violations? And you know what that response from that board member was? Quote, nope, I don't have a problem with that at all. Chairman Eklund, Chairman Boner, I once again ask that this committee launch a full audit of this case, and that this particular administrative ruling be instated as recommended by the Office of Administrative Hearings. You know, you can have the finest legislation, you can have the finest rules, policies, and procedures, but it really comes down to the type of people who you elect and who ultimately appoint people to be in these positions. And if they're not going to administer and implement, enforce the written rules and policies as written, then we're wasting our time. At least, if you want to have an agency that wants to have the latitude to engage in a whole host of unwritten policies, then at least extend that same level of courtesy to everyone who's involved so that everybody knows what the rules are and can participate. But none of this preferential treatment stuff. And with that, that's all I have. Thank you, Chairman Eklund, Chairman Moner. I'll be happy to answer any questions if you have any. Thank you.
Committee, do we have some questions? I think we understand how this went. This point in time, there aren't any questions. I'd like to bring the State Land Board up or the State Lands Office up, and maybe we can ask them some questions and try to clear some of this up. Okay. Office of State Lands, can you come up and help us with questions we might have? I guess I would have one. Maybe to start this off, the House Bill 3 that we just passed, would a case like this that's been done previously to the change, though minor in vacant lands, does it pertain to that previous case or not? Because in some ways we were trying to just clear up the vacant lands statute.
Mr. Chairman, I'm not sure that the new rule would necessarily, I don't know, Deputy, perhaps you want to comment on that, but this is a complicated matter that obviously started before my tenure at OSLI. And it's more complicated. I think, Mr. Lehman has his view of the facts. We have ours. It's also complicated by the fact that there has been attorney advice both to OSLI as well as independent attorney advice to the board itself. So I'm not sure that we can specifically speak to all of the issues that are here based on the attorney-client privilege, but perhaps Deputy Director Crowder can talk about what he's comfortable discussing.
Go ahead, Deputy.
Thank you, Mr. Chairman. And I apologize. We can provide the committee with all the documents we have related to this case, and it's been a few years since I've reviewed all the facts, so I may not be able to answer every single question. I do feel like we recognize and appreciate the frustration that Mr. Lehman has presented here, and I've understood that through the whole process. I can't dispute anything that happened before the vacant land process was employed in his situation, and his rendition of the facts are largely correct, that that property was utilized under a temporary use permit for grazing, and that wasn't the appropriate vehicle at the time to go as long as it did. And through staff corrections and course changes, we've remedied that situation and hope to do better going forward. I will also just give you an update on House Bill 3 that does go into effect on July 1st. We did present that to the Board of Land Commissioners as a rule change last Thursday. They did approve us to move forward with emergency rules so that we could utilize the new statute, House Bill 3, within our vacant leasing process in the near term, and also allowed us to initiate the regular rulemaking process to ensure that we're compliant with House Bill 3 as we lease vacant lands going forward. One of the key notes of House Bill 3 is that it gives preference to lessees, owners, or occupants of adjoining lands in that process. In Mr. Lehman's case, both applicants owned adjoining lands to those parcels. And so I don't know that it would rectify the situation, because at this point they would both be granted the preference in that process. But Mr. Chairman, other than that, I'm happy to dig into the file and provide you with all the other information we have.
Okay, yeah. Chairman Boner?
Yeah, Mr. Chairman, and part of the point of the bill you see is pretty prescriptive in terms of the process, and that the goal was to eliminate the haphazard application of rules, as you know, that was part of the concern. But I guess standing concern is also the amount of time we have, you know, that land stayed vacant, which of course is you know, a concern, I think, if we're going to be wanting to get our constitutionally obligated value out of it. And so, you know, as far as what we can do today, I would just a brief question regarding the amount of vacant leases that we have. Would you say you have an above average amount of vacant leases currently just out there? Where are we at in terms of the number of vacant leases or vacant lands that do not have lease, I should say?
Mr. Chairman, Mr. Co-Chair, that's a great question. The last tally we had was close to 140 vacant leases, which is way higher than anything we've ever experienced in the past. A large part of that is due to a few different things. One is the cases like Mr. Lehman and a couple of those that followed highlighted the fact, exactly like you mentioned, that our process was not codified in rule and was not supported by statute, and it was an internal policy, and that needed to be corrected through the Board of Land Commissioners' minds before we moved forward. So we did initiate that rulemaking process, and we worked with this committee to try to generate a statute that we could also follow and have that supported. But in the meantime, we were held from offering any lands for vacant leasing. And as you can imagine, each year that just increases in number as leases go vacant, as people don't make payments or otherwise don't comply with lease terms. So right now, the number is close to 140. As we've indicated to the board, we have rededicated staff to work on this issue. They are offering anywhere from 6 to 8 leases each month to try to clean up these as quickly as we can. And that's the only reason we asked for the emergency rules, so that we could continue that process and continue those that are in the grind to keep moving, and we wouldn't have a break-in process as we've experienced over the last few years.
All right. So for the most part, you'll furnish us with some information. It'll be fairly confidential because of attorney privileges or client privileges, or is this, I'm not sure what kind of information we're going to get.
Mr. Chairman, we can certainly provide the committee with the file, if you will, as far as what is in there. But with respect to any sort of advice that OSLI received from the Attorney General's office or that the board received independently, that will not be included in there. That's attorney-client privileged, and I don't think it's been waived. But we can certainly provide you with the factual information.
Okay.
Excuse me, Mr. Chairman, and we can provide you with a chronology of events and how that went too.
Okay. Representative Wharf.
Thank you, Mr. Chairman. You heard a request made that an audit be performed to evaluate that. Is that in fact the proper procedure? Is that the proper terminology? Is it an audit? Because I know we weren't given any names other than Mr. Lehman's name, but I'm afraid we have a bit of a conflict, because I think there's a chance that the past director also happens to be the Attorney General today. And I am concerned, I don't know enough about the issue, but what I heard today is very troubling to me. I am a guy that believes if we have rules, we have laws, we have to follow them. And if somebody didn't follow those rules, there should be consequences. And so I guess that's the question I have. I want to know if that's the proper terminology. Clearly, that's the direction I'm leaning, is I want to look at this, and I want to look more at it than just what's in a file. I think we need to dive a little bit deeper.
Mr. Chairman, Representative Wharf, there was also a legal appeal process that could have occurred here, I think, to the district court and beyond, and I do not believe that that was followed. So there was a process that somebody could have availed themselves of. With respect to an audit, I don't think that I've participated in an audit before in my 3 years. Deputy Director, have you?
Good. Mr. Chairman, Representative Wharf, I haven't either in the last 3 years. However, we're happy to provide every fact and detail that we have related to this situation for you, and whatever term that comes under.
And Mr. Chairman, Representative Wharf, we can also provide you with sort of our reasoning, obviously, for the directions we pursued. We just can't provide you the legal advice, if you will, but we can certainly provide you with our view. And clearly, we have a little bit different view than Mr. Lehman.
Okay, can the legal process you're talking about through the court system be done now?
Mr.
Or are we
Chairman,
past that time?
Mr. Chairman, I believe those deadlines have long expired, so it would be too late to go to the courts.
Okay, Representative Wharf.
And Mr. Chairman and Director, I guess what I'm trying to get at is, we just passed, was referenced House Bill 3, dealing with all these vacated lands. I guess one of the things that I see just looking at this from 1,000 feet or 30,000 feet, I just want to make sure that we've captured everything in House Bill 3 that we needed to stop this from happening again, because I know that I've been involved in land exchanges, and I know that they can be very political at times. And I want to make sure that we didn't have any improprieties that took place. And I want to make sure that House Bill 3 adequately addresses that. And I guess that's one reason why I would like to have this committee maybe do a deep dive into this and have an investigation and assess what happened. There's no way that we can correct the wrong, but we can make sure that it's not repeated. And I don't know what else we can do other than look at it and make sure that House Bill 3 is adequately addressing those problems so that we don't have this again, because it sounds like a mess to me. But I am not an attorney. I haven't stayed in a Holiday Inn Express for a while, so it's above my level, but I do think it warrants looking into. And I don't want to just look at the files. I think this committee needs to really look at it with an assessment as far as whether or not House Bill 3 did sufficiently stop this from being a recurring problem. If we've got as much vacant leases as we have, I don't want to keep hearing of another problem because we didn't cover it. So that's the basis. And I guess we're going to take a break for lunch at some point. I would like to visit with some members to figure out what we want to do, but I would, thank you.
Yeah, Mr. Chairman, I think it is important we get to other public testimony before lunch. Like I said, people have lives outside of sitting in a committee room. But yeah, I think we set up the process in legislature, right? Then we leave it to the Board of Land Commissioners to make decisions, perhaps at our next meeting when we have a few bill drafts before us. We can invite some of those board members to appear before the committee as they have in the past. And perhaps that would be a good way of, if we have opportunity to review some of these details, then we can be prepared to ask them some questions. So short of, the election process to determine who those 5 members are, all that we can, we have those opportunities as citizens, and we have the process we set up in the legislature, which is what we did with House Bill 3. But that might be a good path forward, I would submit.
Okay, I think we'll probably be extending the meeting at least till 12:30 so that people are kind of aware what's going on, and we'll continue to have public testimony, and hopefully nobody's too hungry. Who would like to come on up, ma'am? So state your name.
Hi, Mr. Chairman. My name is Christy Bolander. I'm from Converse County, and I'm a rancher there.
Bollinger?
Bolander.
Okay. And you?
I'm Jenny Miller, also a rancher.
Jenny Miller.
Sister.
All right, who wants to go first?
I will.
Go ahead, Christy.
I'm here today to talk about an exchange going on right now with EOG. There's a state land exchange, and they're trying to exchange 8 sections of land in Converse County and Campbell County, or some around Cheyenne. And we have several concerns about it. One being that this precedent will be set. Sorry, I need to just take a breath. I'm very nervous.
Okay, there are many of us that have tried to be invisible all of our life, and it just doesn't work out.
Yeah.
Just relax.
Okay.
Go along as best you can.
Yes, that big corporations will come in and just exchange land. We're worried that they're trying to bypass paying surface damages and access fees to drill on these lands. The section, the I-lease is over 8 miles from the county road, which causes a lot of concerns. Dust, traffic is a big one. Lambing would really affect our livestock. And it also is next to our neighbor's land that they don't have access to. So we worry that they would go, use it for that to get access to neighbors and further increase traffic. And since the exchange has come forward, it's been a big concern because they've been using the exchange to negotiate with other adjacent landowners to get things done, not in the favor of the landowners, the adjacent landowners. So for those reasons, we're just really concerned about that this could become if this exchange is accepted, there will be another big corporation, coming through, and the precedent will be set that this landlocked state sections can just be traded to the highest bidder, essentially.
Committee, any questions? Mrs. Miller, you can go ahead and start up when you're ready.
Okay. Yep, the same thing, just kind of talking about leasing state lands. With the land exchange process, it seems like a lot of courtesy is given to occupants of adjoining lands, and it seems like with the land exchange, that it kind of took us very much by surprise, and there's no opportunity for buying that land rather than once kind of the wheels are in motion. Seems like there's no opportunity for us to have any, opportunity to buy the land or trade it. And we have a lot of other state land that's pretty close to our house, and kind of, if this precedent is set, makes for just looking over our shoulder all the time at who's the next highest or the next big corporation that could come in and do the same thing and develop a lot of, oil and gas facilities that would really impact our way of life and our ranching operation.
Okay, questions? Yes, Chairman Boner.
Well, appreciate both of you being down here. And just to be clear for the committee, there's statutes that deal with good faith negotiations with the landowner. There's a process that an oil and gas company goes through if they don't think the landowner is negotiating good faith. And I see this as an obvious attempt to circumvent all of those statutes, which we fought over, over the decades here in this legislature, to prevent these sorts of situations from happening. A large oil and gas firm from out of state coming in, just running roughshod over our citizens. In this case, they're utilizing, as far as I'm concerned, the state of Wyoming in this land exchange process as a weapon against a multi-generational Wyoming family. And I think it denotes a criminal mindset on their part, frankly. I've said that publicly before. And of course, the E and EOG stands for Enron. I've pointed out before publicly, I'll continue to publicly point it out. It doesn't represent all oil and gas firms, but you can see how criminal this exchange is, because they're using our process as a negotiation tool because apparently they don't have the wherewithal to negotiate in good faith in the private sector. So just want to, a little bit more background. With all that being said, I'll get to a question here soon. But how long did you negotiate with EOG before they initiate this land exchange process? And could you characterize the nature of those negotiations and what they're offering you, say, in terms of what you, I mean, we all know what the market rate is for a lot of these things, for road access, for water disposal, things like that. What did you characterize their offers in terms of, percentage of the overall market rate?
Well, we've actually done a lot of business with EOG. We've worked really well with them. So they didn't want anything on this state section, as they talked about a little bit of development, which we were open to. It wasn't, like I say, we were blindsided by it. We didn't know that they were going to do it. They've paid, with our agreements, they're paying fair market price. I think they've had kind of a change in management, and they've started offering, like for water access, like half of what the market rate is. And I think they're trying to lower the market rate, but we try to keep in touch with the neighbors, what everyone's getting, to see if what they're saying is valid. So there's nothing that I know of that they're working on specifically on this section that they want to exchange. And there's no reason that we couldn't negotiate something with them. We've had no problems in the past. So we have no problem negotiating with them. We've gotten along with them for many years. And so I don't know.
So who's the land exchanged with? It's not with the oil company that you're used to dealing with. It's another one, or?
No, it is.
Oh, it's the same one.
It's EOG, the oil company.
Okay.
So.
All right. Representative Clausen.
Mr. Chairman, and either one of you, this is a question for either one of you, but are there other operators in the area that if there was some sort of an auction, I mean, hypothetically, we'd like to keep this revenue for the state, but if there was some sort of an auction for these parcels that they would be interested in bidding far more than, let's say, what's being exchanged for in your area, is there more than one operator in your experience in that part of the world?
I'm sorry, will you repeat the question? An auction for the land itself?
Not necessarily the auction, but is there more than one operator that would be interested in these parcels that operate right there that would maybe pay more than what this exchange process would bring revenue for the state?
Yes, I believe there would be. I think the location of the parcel, it's just one of the sections of the 8. There are definitely other oil companies in the area that would be interested. I'm not sure entirely how that works. If they have the leases on the minerals, I think they can hold the leases for a certain amount of time. So whoever has the minerals leased would get until that expired, which I don't know if those minerals are. It's in the middle of several. Several other people would be interested. But.
Okay, so I guess committee, we're dealing with a whole different complaint here from the last public testimony. I guess what I don't understand, have you been excluded from this process of land exchange where you would acquire the land? It's kind of sounds like you had been, and others were included in it, mostly companies outside of your ranch. Go ahead and talk about that a little bit more.
Okay, thanks, Mr. Chairman. I don't know that we've been excluded. I think it's the way it's set up, it's a difficult process to have a land exchange be successful. We would have to find some land to exchange for this parcel and present it to the state and go through the whole process. So my attorney has said that he thinks the success rate is like maybe 20 to 25%. So that's a pretty big investment for not a guaranteed thing. We would have a chance to exchange it. We just haven't. We don't have anything to exchange it for
Sure.
right now.
Okay, that makes sense. Thank you. Senator Kolb.
Thank you, Mr. Co-Chairman. You said earlier that you were blindsided by this, how this came about. Do you think, what's your opinion about the advertising? Was it, did you have notice, or is it just because maybe, you know, a lot of folks don't notice something until something happens, and of course you notice it. But what's your thoughts on the notice that you, I guess, weren't aware of right away? And could you kind of talk about why you said blindsided? Thank you.
Mr. Chairman and Senator Kolb, we were blindsided by the fact in that we had been in negotiations with EOG, and they had mentioned some things on this parcel of land. And so we did receive a letter from the Office of State Lands and Investment about the exchange. I think that's the only notification we've gotten through this period of the exchange. It's been going on several years now. But we were blindsided by EOG mostly. We didn't know that they were planning this, you know, yeah, because we had been negotiating them for so long. And like I said, we have between my sister's place and mine, they have 57 wells drilled. So it's not like it was a new, you know, we weren't on bad terms, or so we were surprised that they would try to exchange this section when we were getting along fine and negotiating other things fine. So yeah, just blindsided by the company, not necessarily the state lands and investments.
Committee, other questions? All right. Well, thank you very much. So committee, we have to separate the different complaints that are going on here. I don't know if the committee will be able to resolve the land exchange part of it, but okay, he has a plan, better plan than I do. So thank you so much. So next we have go ahead, Senator.
Just a quick question for state lands, just where we're at in this process with the EOG land exchange. I know you have a nice, pretty, you know, chart that tells us the process, and just can you tell us where we're at in that process and when we can expect the board to have to make a final decision on this?
Mr. Chairman, Mr. Co-Chairman, I believe the EOG proposal has been moved to the Category 2. It was brought to the board in executive session. The board did then take it as a walk-in matter and voted to move forward with the exchange as presented. And since that time, I'm not sure if there have been some different lands proposed or different things like that. Deputy Director Crowder would know more, but it's sort of sitting there now. We have not negotiated the agreement to initiate, so it's sort of there in the process. Deputy Director.
Mr. Chairman, Mr. Co-Chair, so at the October 7th, 2021 board meeting, the board approved the office to move forward with the analysis piece of this transaction. And that's really the beginning of it, as we start digging into the parcels that were identified, the revenue generating potential of those parcels that were identified, and start analyzing the parcels that we could acquire in the exchange. This is where the appraisals come into play as well. We need to initiate that process. But at the very beginning of that, needs to be an agreement, as the director mentioned, where we negotiate what we call an ATI, an agreement to initiate, basically the roadmap for the transaction, who will pay for what, who will do what, and by when, and we're still negotiating that. So because we're this early in the process, it's very hard to say when the next step in the process will occur and when the next time the Board of Land Commissioners will hear it. But as also the director mentioned, we have the public process still to go through after the detailed analysis is written, and all that's still out in front of us.
Senator.
Mr. Chairman, and my concern is that this process is being abused as leverage against, in a private negotiation. And so that its mere existence is problematic to me from that regard. So is there an opportunity for the board to rescind that decision, to stop the process at their next meeting potentially, or?
Mr. Chairman, Mr. Co-Chairman, It's a good question. Procedurally, I would think if we go through the, at this point, I don't know what evidence we have that the process is being abused. We haven't heard from EOG. We haven't sort of had this testimony, but certainly I would think if this came to the board's attention that they might consider something like that. Otherwise, maybe they want to get through the public comment period and figure out what to do after that. Deputy, your thoughts?
My only addition, Mr. Chair, Mr. Co-Chair, is that we went through a rule change last year and presented that to you all. Part of that rule change is if the director determines that a transaction is not meeting trust land management objectives, that she can stop the process at that point. But again, everything that's been discussed so far today is separate from trust land management objectives, and that's what the rule is expected to address.
Okay, so a little bit more explanation as to my concern then. We have statutes that deal with these situations, these very tense, very difficult situations where there's a conflict between a company that wants to develop the mineral estate and the surface owner. Those are difficult statutes to discuss. They've been hard fought over the years, and there's a process to go through if either party feels like they are not being treated fairly. This land exchange circumvents all of that. That's why I say I'm not saying that it's illegal. I think they're very smart. They're like the smartest guys in the room, right? The oil and gas company, that's their reputation, right? And so they are utilizing this exchange process to circumvent our laws. I find that to be very much a criminal mindset. And so I'm not saying they're necessarily doing anything illegal, but they're doing something that flies in the face of the intent of our laws. That's why I'm deeply offended by the entire notion, this entire situation, because it has serious consequences for our state and our citizens if we allow an oil and gas company just to come in and use this land exchange process to avoid negotiation with the surface owner. So that's my concern. That's why I say that the process is being abused. Just make sure we're absolutely clear. I guess I don't need to, it's not a question, Mr. Chairman. I felt that deserves some explanation. So I understand that you're following your rules as they exist. I'm not accusing state lands of anything, but I just wish we'd be a little bit more cognizant of the context in which this development is happening and the context in which this particular land exchange is occurring. So that's why we're taking the extraordinary step of discussing it as it's in the process.
Okay, committee. Thank you. Yeah, we've got more public testimony. Come on up.
And I'm just really interested in the start of this and the operator that was mentioned earlier, they added two of our state sections into those in exchange. The difference though is we operated this as land trade, we offered them our deed land in exchange for these state sections, and our applications actually had operators. And they denied it without any investigation and to add those sections in. So we're just saying about, I just see it as a dangerous.
Okay. Committee questions? Yeah, Representative Fortner.
On these lands for trade, is the state has mineral royalties underneath those sections. Is there option for the state to set up a pad, a multi-pad, somewhere off on your guys' private grounds to set up a pad with, say, 6 or 8 whips on it, 6 or 8 locations, to whip each one of them school sections so they can recoup that mineral? If you guys just want the surface, right? Would you be willing to do that?
We're nervous about the operator and I mean, these sections are unlocked for the adjoining land. So there would be that option to set up a way to get to that mineral.
Okay, thank you.
Okay. So I guess I'm not real clear on why you were denied So you tried to make a land exchange with lands that you had for these. These lands are probably lying closer and more essential to your operation than the other ones.
We offered some deeded acreage of our own, and they also have access to a huge part of that. These state sections, there's no roads, and there's nothing, it's completely, they're island borders. But the land that we offer to state is considerable value. And we have no idea, there was never any explanation of as to why it's more than as far as we actually didn't even hear that it was directly.
Okay. Committee, yes. Senator Kolb.
Yeah, thank you, Mr. Co-Chair. Just a question. So you haven't had the opportunity to appeal it yet? No. Okay. Well, I look forward to hearing that happening. Thank you.
Okay. All right. Yes. Representative Larson.
Yes, Mr. Chairman, thank you. You said the land that we're talking about is landlocked? They can't get to them, is that correct?
And this same operator, our neighbors, they've been through negotiations with them. We're in the process as well. It's been 14 years of us. And we're going to come to the invitation, but it's just the latest.
Okay, well, thank you. Can Office of State Lands comment on any of this conversation we've had? Such as why they think they're not going to get a chance to get into this land exchange?
Mr. Chairman, I would defer to Deputy Director Crowder. I'm not familiar with all the specific details of this proposed exchange. So I would just be speculating that our real estate analyst and appraisers may not have agreed with the previous speaker, but Deputy, do you know more than that?
Mr. Chairman, and without going back and reviewing all the details, I'd have to do the same as the director, other than to highlight the process for you. So again, through that flow chart, we get an application in, we review it internally, and it goes to what we call internal review team. And that's where we pull the director, appraisers, land managers, commercial managers of all different aspects of the office together to review a transaction to see if it meets the trust land management objectives. And if it doesn't meet the trust land management objectives, or if it has an equal impact on the trust land management objectives, it could be denied at that point. And it appears that this transaction was denied at that point. And after that, we would have to go back and review the file to see exactly what the attributes were.
Okay. Yeah. Senator French.
I clearly admit I'm really confused now on this one. Does that oil company have legal access to those sections that they're trying to acquire, or do have a land exchange somewhere else? Or are they in the process of trying to negotiate access with those surrounding ranches? Because if they don't have legal access there, I don't know how they're going to develop that. Does anybody know that?
Mr. Chairman, Senator French, as I stated before, we're very early in this process. And what we asked the Board of Land Commissioners to allow us to do is to dig into the analysis of questions of exactly that nature. So we haven't done that analysis yet, and I'm not sure what access points they have or don't have at this point. But those would be flushed out in the detailed analysis as we work through it.
Yeah, so I guess on that point, possibly the access they have is that they own the lease on minerals on that state land is my guess. That you can't really be denied of property, so I don't, there may not be a road to it, but if you own some minerals somewhere, you've got to be able to have access to them. And they don't exactly own them, but they have the lease on them, so it's kind of the same thing.
And Mr. Chairman, I think your speculation is what we would speculate as well. We're not sure exactly all the ins and outs of that. But I would also just mention that our rules and the statute allows any person to nominate any land for a sale or exchange. So it doesn't talk about access. It doesn't limit those applications based on access.
Okay. And then that application, the first application, has precedent or priority over the next application or not? Okay,
Mr. Chairman,
not really.
it doesn't. We don't do it as first in right, first in time. We do it at which transaction, which application brings the most benefit to the Trustland beneficiaries.
All right. We'll start over here again. Representative.
Thank you, Mr. Chairman.
Go ahead.
Is there a place, or can you provide for us the minutes or all the information that would pertain to this property that was rejected?
Mr. Chairman, Representative Blackburn, we can provide you all of the file information that we have on the land transaction that was rejected at the IRT stage. There's not a lot of information because it was very early in the process, but happy to do that.
Follow up.
When can you do that? This afternoon, tomorrow, next week?
Mr. Chairman, we can raise it very high in priority to get you that information.
Okay, so maybe this afternoon. Okay, thank you, Deputy. Representative Western.
Thank you, Mr. Chairman. Mr. Crowder, are there any Category 1 applications currently pending, and if so, where are they?
Mr. Chairman, Representative Western, we do have Category 1 transactions pending. As you're aware, Category 1 is the initial application phase until the Board of Land Commissioners moves it forward to a public process. Our rules require that those transactions be held in confidence while we work through that process. So I can tell you we do have Category 1 transactions. I can't tell you exactly where they are because we're required to hold them in confidence.
Are we good, committee? Okay, do we have more public testimony? Yes, go ahead. Follow up from, are you Mrs. Lehman? Okay. Go ahead and state your name for the record.
Hi, my name is Gigi Lehman. I'm John Lehman's wife. With regards to the question, with regards to the appeal process, which would have been a second appeal process of the contested case hearing for the vacant land, the reason why that was not moved forward in district court, I'm a certified paralegal, and when talking with our lawyer, I can just tell you that how that order was drafted by the AG's office, how the district court, it's my understanding, would look at that, is to look at whether or not everything that was looked at in the Office of Administrative Hearings was looked at and addressed to some degree in that order. And the land commissioners have the right to decide those decisions. And so the state of Wyoming court system would not necessarily impede upon that process of what the state land board can do with regards to their own process. So that's why my husband's asking for an audit or investigation done on this particular case, because it's all controlled through the AG's office. And the AG herself, actually, the current director had recused herself, well, actually stepped aside and let the current AG and an assistant AG, I guess, or a lawyer, not sure, because this happened right at the start of COVID when this order was determined at that point. And so we weren't allowed to be in there. It was all on Zoom. Our attorney did not get the order ahead of time, and no public comment was allowed. And so with that said, I think this is very important to the people of the state of Wyoming to understand what particularly happened in this particular case, because it sets a huge precedence, or at least raises huge flags as to what was happening within that office. For the 8 years that my husband was trying to get this lease, squared away with the State Lands Office. And the entity that came in towards the end of the 8 years and acquired some land that was a sliver of it next to that 8710, miraculously, they were able to make these 2 leases. This is important to then, within months, to deal with. So the entity is huge that came in there to do that and acquired tons of land, hundreds of thousands of acres in just 19 years in this state. So I think you need to look into it, and I just wanted to clarify why that was not appealed.
Okay, so hang on. I'm not sure I understand. So you did try to go through the legal process that
Through the
was spoken
OAH,
of,
yep.
right? And that was kind of undermined by the Attorney General who took over that process, or it just died because of COVID, or I'm not sure.
So after the end of going through the OAH process, where the OAH hearing examiner found in favor of John Lehman, with all the evidence and testimony given on behalf of OSLI, as well as the other party that bidded on was the successful bidder. My husband was the unsuccessful bidder. Anyways, with regards to that, that process took a little over a year. And so by the time the board then looked at that and gave their final determination was at the start of COVID.
Okay. All right, so you did attempt to do the legal process.
Absolutely,
has
we did.
expired. Okay.
Yep.
That's what I needed to know. Any other questions? I think we might, we might have one more for you. Senator Cole.
Thank you, Mr. Co-Chair. This goes to the director.
Okay.
Particularly when the State Land Investment Board, if I'm going to say this correctly, makes a Board of Land Commissioners makes a determination on what's in the best financial interest for the state of Wyoming. Do they write this down on paper? Do they actually come up with a calculation that says it's X and Y when it comes up to these questions or these situations I've just heard of? When they make a determination, is there numbers behind that determination? Thank you,
Mr. Chairman, Senator Kolb, I'm not sure if it's specific numbers with respect to an analysis, but when we have a contested case such as was the situation in the Lehman matter, there are findings of fact, conclusions of law that the board issues after that. And how the process goes is if somebody wants to appeal the director's decision in a contested situation where you have 2 people, 2 or more applicants vying for the same lease, that gets appealed to the Office of Administrative Hearings. The Office of Administrative Hearings then takes the facts and the testimony, comes up with proposed findings of fact, conclusions of law, and then provides that to the Board of Land Commissioners for their consideration. The Board of Land Commissioners can choose to adopt that or choose to reject it and issue its own findings of fact, conclusions of law. And I believe at that point in time, there were a number of other similarly situated appeals going on. And so there were some consistency concerns with the board and other things, but that's all part of our file that we can certainly provide to this body for consideration. But with respect to a numbers analysis, I do not believe there's that in this case.
Follow
up.
I find it disconcerting that you're saying there's 2 different findings of fact potentially after the analysis. I think, I don't know, I hate to use the word woke, but you try to come up with things that are supposedly 2 competing facts. Well, that's just not in the world of reality. So I'd hope we come up with one fact at the end of an analysis that said it's X or Y, and that's why it was done. I think the public deserves to know what that answer was and how it came to be, because it's public information, I feel, that should be known, because I think the more we do, if we're more open about it, I think there's less questions about it. So anyway, thank you for trying to do the best you could answering the question.
Okay, we're going to break for lunch. There might be a little more public testimony, I'm not sure, after lunch, and then we get into forest management, I think. And we'll have to eat a little bit quick, but 2 o'clock we'll reconvene here in this meeting room.